we are law-fearing people also. It says no, you don't have to be friends with a policeman, a doctor, and a lawyer. Don't be friends with them, friends or enemies, both of them.
You should not fear the law. Law is there to protect you, not to put you under the constant threat of something.
Everybody in society, generally are like, why is he supporting that murderer or that rape accused or this, offender, or all these things happen. Your family was like, no, don't do it, and then you did it, and then something else came out of it.
You won't believe. Most of the associates in my office were like, sir, don't take this case. We are not finding. So she was going through school bus, and the conductor of the school bus assaulted this child. There are CCTV cameras in each and every school bus. The moment the bus leaves, the camera is switched on. The first person to get into the bus is a school teacher. The first person to get out of the last person to get out of the bus is a school. I have a case where the allegation for rape came after 22 years. The woman says that this person has assaulted me for 22 years. There was this extramarital affair going on between the parties, and she was, of course, getting a good amount of money. Beta is bedridden, he cannot get up on his feet. Don't believe. The husband of the lady, he came in as a witness and said, nah, my wife was having sexual relationship with the woman. ये जो tag है ना, accused the person, this never goes away.
Hello, everyone. Welcome to Lextalk, a podcast where we discuss everything legal. And this is the premiere of Lextalk podcast. We all think that legal is a very difficult deal. It's very complicated. You don't know how it works, but it's not really. And to break that norm, we had an opportunity to discuss all of this with Shivender Kumar Sharma. Shivender is a practicing lawyer. He's a criminal litigation practitioner. And in all of this discussion, we have talked about so many things. How he wanted to become a chef, but became a lawyer. And how his first case make him so intrigued about that he just left his initial dream aside and finally became a successful lawyer. His journey, his experiences, his cases, that will definitely give you a lot of goosebumps. So stay tuned. I hope you will enjoy this episode. And if you like this, please like this video and click on that red button and subscribe to Lex Talks channel. I'll see you in the session. Thank you. Hi, Shivendra. How are you?
Hello, I'm good. How are you?
I'm great. I'm great. Thank you very much for joining us on this session. And
It's a pleasure.
we are eagerly looking forward to have some crazy stories coming out of you and know your journey of being a criminal litigation lawyer. But before we do any of that, let's just understand how all of this started, how Shivendra Kumar Sharma became a lawyer.
Uh, this was an accident. It was by chance. I never planned to be a lawyer. I never planned to pursue law. I always wanted to be a chef. I after school, I got myself enrolled in a culinary school. So I was there for quite a few time. Couple of months, I believe I was there, and somehow things didn't work out. And then I don't know, law things. It was just because I always wanted to open a restaurant. I wanted to be a chef, and the other course which I was waiting for, there was some time that for the course to start, and my father was like, meanwhile, just to kill time, you should enroll yourself in something. You'll get to meet people. You'll make new friends. Why to waste time? Why to be at home? So I got myself enrolled in a LLB course, and yeah, that's how the story starts.
So great. I guess then you were trying to cook something, but Destiny was cooking something else for you.
Yeah. Certainly.
Perfect, perfect. So,
Said, "No, you have plans, then God have plans."
right, right. Yes, yes, that's what they say. So you've never planned to be a lawyer, but then became a lawyer. Was your father a lawyer? I mean, was your
No, I'm a
family?
first generation lawyer. No one in my family is a lawyer. And I was very sure that I'm gonna drop it. I'm gonna drop it in, I think, after a couple of sems. But There is this thing, there was this thing in our college that there were internship period of 1.5 months was necessary after every 2 semesters. So during that phase, it was my first internship that came as a surprise and a turning point in my life, because I am today what I am is because of that 1.5 month of internship.
Yeah, yeah. Okay. Um, okay, so I guess we don't have anything in the past. Let's just get started from as soon as you became a lawyer. Um, First of all, what is it with law? I mean, people like me don't really understand how law really works. I mean, how lawyers work, how this a typical life of lawyer looks like. So, how does your life looks like as a lawyer?
It certainly doesn't look like what they show in movies.
It's
That's
not
one
what
thing.
they make you feel in suits, yeah?
Yeah, courts are far more different than what you're shown, and it's all more realistic. See, coming back to your question, understanding law is per se not that difficult, but the implementation of law is that is something which where we as a lawyers as a part of the judicial systems come in and plug the foundations and the required interpretations. So that, see, if you'll say law is same for everyone in this country, for a lawyer, and it is very, very necessary for every citizen of this country to know what law is, especially what is an offense, what are the criminal laws, and what are the basic, if for example, not even criminal law, if someone is into business transaction, they should know what the law is, what are the income tax regimes, what are the implications of certain transactions. So that's something which every person should know about. But the implementation of same and the compliances of the same, that's where the interpretation comes in, and then that interpretation, for that interpretation, judiciary is required, and to assist judiciary, lawyers are required. So that
Okay.
is the role of a lawyer. It's not, see, it'll be a cliche if I'll tell you that it will be for rights of the people, voice of the people, voice of unheard. Okay, all that is there, but that's cliche. Interpretation of the law for the compliances to assist judiciary for interpretation. For example, recently the criminal law has been changed to the very core.
Yeah, we're
We
going
have
to talk
a new
about
code.
that. Yeah,
Yeah,
for sure.
we have a new code. So for its interpretation, now every person in this country is required to know what's an offense under that particular act. But for interpretation, so whether a act committed is an offense per se under that act or not, under that code or not, for that judiciary is required, and for to assist judiciary, lawyers are required. And for both sides, for the prosecution, there will be an interpretation. For defense, there will be an interpretation. So, what is the correct interpretation, and what is the logic behind that interpretation? How it connects to the very constitution of this country? Is it ultra virus or is it intra virus? That needs to be interpreted. So, there a role of a lawyer comes in. So
What
that's
is
why
ultra virus and intra virus?
what's outside the scope of constitution, what's inside the constitution, which the thing, a law in the every law in this country cannot go ultra virus of constitution of India.
That means out of constitution.
It cannot be in contradiction to the constitution. So whatever there is in our constitution, we have a very beautiful written piece of constitution. No law can be made and can be enforced which is ultra virus to it. So it has to be within the ambit of the constitution. Whatever law says contrary to what's there in the constitution is ultra virus. It's not
Okay.
in the scope.
Okay. 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 That's interesting.
Mhm.
So what you are basically saying is that there are certain laws, and there is a place where law can be used to resolve a lot of issues, let's say. And lawyers are needed to basically bridge this.
Bridge this.
Right. Okay. Makes sense. Uh, Okay, let's do this. We know there are courts. We know there are courts, there are lawyers. But the initial part of the bridge, let's say A to B, but the A, like people like me, we are not that much aware about the kind of laws that exist around us. Yeah,
Mm,
and that's a fact. Or we are law-fearing people also. It says no, you don't have to be friends with a policeman, a doctor, and a lawyer. Don't be friends with them, friends or enemies, both of them.
mm.
So why do you think that exists?
See, I believe that is a misconception. Uh, no one in this country should be a law-fearing person. Everyone should be law-abiding person. There is a very fine line of distinction between both. You should not fear the law. Law is there to protect you, not to put you under the constant threat of something. Something wrong is going to happen to you if you not follow it. All right. We don't work on deterrence theory. We don't, Indian constitution is not that. But a law-abiding citizen, it's your duty to abide by the law for a peaceful society, for nation to work. So there is a difference. So that is the misconception. It is a very general misconception. And I would say most of the people, everyone is fear of law, is in fear of law. You don't have to be in fear of law. You just have to abide by the law. Right. Another example, I'll give you an example. Let's say there is a person who's a businessman, he's running his business. He is filing his GST returns quarterly or half yearly or yearly, whatever. Uh, so that is abiding by the law. That is not the fear. Fear would be I have to file it, otherwise I won't be able to work. Otherwise, I won't be able to run my business. That is fear. They'll stop my business or they'll seal my premises or do, which of course they have provisions to do so if you are in the conflict with the law. But a person should never be under fear of law
Right,
unless we talk about laws which are of national security and all. In general, a person should be a law-abiding person. That's all it is required. You should be aware of the general laws. Of course, government doesn't expect you to know laws which are technicals, which run on mere technicalities. They don't require you to know that law, and you are not required to know that also. Na? That is for lawyers to know, and that is for the professors of law school, that is for the judiciary judges, that is for the law enforcement agencies, departments which are enforcing those laws. So that is for them to learn. But for
right,
general people, for the citizens of India, it is not necessary. Only the general law. One should know if I'm going to take something away from someone, that is an offense. Forcefully. If I'm going to forge a document, that is an offense. If I'm forging someone's signature on a document and gaining some benefit out of it, that is an offense. So that's all the principle, the general principle everyone should know
right, right. So that
and
means we
abide by that.
always,
Not be in
yeah,
fear of it, abide by it.
yeah, we should always have a lawyer friend around us to kind of keep us on
It's
track.
not necessary to have a lawyer friend, but you should know someone who's a lawyer who has a practice in law.
Oh, that's right. That's right. Okay, Shavendra, you are very young. We see lawyers with
Mm.
white shirts and black coats, and serious man, bit arrogant, um, cliche again. But you're smart. You look like someone who plays basketball and represents some state for India. Something like that. By the way, for our viewers, he's 6'2". Actually, he can. If you look at him, he looks like a basketball player. But you became a lawyer, and you said that was completely out of chance, and it all happened with you. You must remember your first case. Everybody remembers.
I do,
What happened?
I do. In fact, I'll share a story with you, which takes back to my internship, that how it all happened, how it changed my perspective, my outlook towards this profession altogether. I was I was in third semester, I believe.
Which year
Yeah.
it was?
Second year, third semester.
Okay.
So as I told you, that there is a mandatory internship that that everyone has to go through, has to pursue. So I was with Mr. Rakesh Malhotra. Shri Rakesh Malhotra is a very fine lawyer. So that was my first internship, and one of my neighbors was chamber junior to Mr. Malhotra, so he got me an internship over there. So while I was interning, I one day we were in the High Court, Delhi High Court, and we were done for the day. I think it was a post-lunch session, and suddenly I saw that Mr. Malhotra is meeting someone, lawyer. He touched his feet, and yeah, of course, all we were there, and his juniors were touching his feet. I also went up and I greeted him and touched his feet. So I came to know that Shri Mukesh Kalia, the lawyer. So Mr. Malhotra greeted him, and then, of course, he was getting late for his matter, so Mr. Kalia left, and Mr. Malhotra told us we were two interns over there at that point of time, and he told us that we are done for the day. If you want to head to office, you can head to office. If you want to go home, you can go home, or if you really want to learn, sir is going to argue a matter which is a very interesting matter. You should go and make notes of it, and we'll discuss it by end of the week or on some day, but you'll get to learn and go hear what is observe what he's arguing.
Mm-hmm.
So followed him. I became his tail, and of course I followed Mr. Kali and went there. He argued a NDPS matter, narcotics matter, that day.
And NDPS stands for?
Narcotics, it's a act which stands for NDPS, narcotics, drugs and psychotropic substances. It's an act which regulates narcotics, drugs, and psychotropic substance.
Okay.
Whichever pharmaceutical or a drug or in layman language, hashish and
Cocaine,
cocaine,
heroin, all
heroin,
these
and
drugs. Yeah.
everything.
Okay.
And if, of course, opium, psychotropic substances also, which have medical use also. All right.
Okay.
So all that it's a act governing all those substances. So he was arguing a matter. It was a matter in which the guy was convicted for life by the Sessions Court, by the special NDPS court, and he was arguing the appeal over there. And my God, man, how he turned it. I remember the learned judge dictating acquittal judgment right there in the court, and I was like, whatever was being argued by the state side, he he has he has rebutted the state's case to the very core. He demolished the very tightly knit fortress of a case which the prosecution has built, which they were able to prove before the special court. And yeah, from that day onwards, I was like, I have to do this. I want to do this. So from that day onwards, me being chef, want to open my own restaurant and everything, and having passion for cooking, it all was kept aside, and all I wanted to do was first to anyhow get an internship under Mr. Mukesh Kalia, and then of course, which luckily I got. Then I got to be his junior. I was chamber junior to him. Then I was a senior associate with him for quite a few years, I believe. For a couple of years, I was there as a senior associate, and then of course I started my own independent practice. But my God, that I cannot. Even if I try, I'm pretty sure that I'm not gonna able to forget that ar- argument. I won't say argument, that piece of art which he portrayed on a canvas that day. The moment he opened and the moment he rested his case was beautiful. So that is what which drove me towards this profession. I was like, yeah, this is something very important, because of course I was pursuing law. So if you do an integrated course in starting for like 2 or 3 semesters, you hardly get any law subjects. But because I was interning that at that point of time, I had read couple of files relating to NDPS Act. So I was having a very, very negligible, I'll say, negligible knowledge of the act. I knew what the sections are. That is all. Interpretation of those, I wasn't aware of, and it was yet for me to learn. So yes, that day was the day that uh, I I made a decision for myself that, of course, I'm going to take this seriously. I'm not going to drop out. I will pursue law, and of course, I'll try to be what he's doing. And that's how I followed. And of course, and I coincidentally, the first matter that I argued, somewhat similar, not relating to narcotics or drugs, but it was a drugs and cosmetic act. I was interning under Mr. Kalia, and by God's grace, I was enrolled as an advocate also when I was interning. So directly, I was recruited by him, and I was his junior.
When you
So
say enrolled as a advocate means?
we have to enroll as an advocate with the state bar council before we can practice. It's a kind of license that every lawyer has to get from the concerned bar council from if they want to practice. And if it's like you are right out of law school, you cannot practice law unless you get yourself enrolled.
Okay, okay. So
So you have
license
to
to
practice.
practice in
Yeah, it's a
courts,
license, not license per se. In layman's term, it can be said
like an
that you have to come
examination
on
kind of
state's
something.
rule. Every
Okay,
bar council of every state has a role of advocates. So you have to have your name on that role. For that, you have to apply. And of course, there is a meeting. They check all if all your documents are in order. And then within a couple of years, you have to take an exam for from Bar Council of India. It's AIB exam. That is very important. If you're not going to take that exam, you cannot practice law. So
okay,
you have to clear
okay,
that. It's a certification that you have to take that you are eligible to practice law.
okay,
So,
okay.
of course, but for that exam to take, you have 2 years after you're getting yourself enrolled in the State Bar Council. So I got
Okay.
myself enrolled on 12th of October, and I argued my first matter on I think 12th of October. It
Which
was
year
in
it was?
Karnal,
12th October
2015.
2015. Okay.
2015.
Remember the date.
So I very clearly remember I was coming to the office and my phone rang and I was going to Tisazari courts and my phone rang and it was Mr. Kali on the call and he said, Beta, where are you? I said, Sir, I'm heading towards Tisazari. So no, no, you don't need to come to Tisazari. I'm sending you over a file and you have to go to Karnal and argue that matter. There is this matter, the drugs and cosmetics. To be very honest, I have never heard of that act prior to that. I never knew that some act like that existed also because you don't learn all that in law schools, no? Because we have n numbers of acts, n numbers of laws. So in law school, you learn the major ones. So I said that I have never read the act, and say I'll brief you. You'll be getting the file on your email. You directly proceed towards Karnal. So of course I rerouted myself towards Karnal and I went there and uh, meanwhile he of course briefed me up and he gave me instructions how to argue and I argued that matter and unfortunately I was not able to secure bail. So I gave him a call and I said the judge was reluctant for even hearing the argument and he was not with me and because he was not happy with the fact that the applicants therein were absconders. So they
Which
were
means
absconders are who try to evade the process of law. So if a person came into knowledge that there is an FIR pending, either he should go to the authority or he should approach the court to get himself a bail if it is a non-bailable offense. And if police is looking for you, you are avoiding your arrest and you are not approaching court for anticipatory bail. So the police will get non-bailable warrants from the concerned court against that person. And then, of course, if non-bailable warrants are there. Then after a period of time, after the compliance, there'll be 82 proceedings. Absconder. They'll
Okay,
be
that's heavy. That's
proclaimed
heavy
as
for our
absconder.
that's heavy for our viewers, I guess. Let me just put it this way. So let's say someone stabbed someone, and that stabbed person filed a complaint, FIR. The
Mm.
person who stabbed the other person, ran, and police is kind of looking for him, and he's just not coming, not even approaching court or not going back to police. That surrender basically. That the way we say it. So they are not surrendering. Also, they're just running.
Or joining the investigation.
Okay, okay. So they're basically avoiding all of this. They're just
Mm.
running. And they're just avoiding all of it. Okay, makes
Then
sense. Yeah, please.
Then, in that case, police will first get NBWs issued by the concerned court. And after executing those NBWs, they'll again seek NBWs. Then again, third time they'll seek NBWs, and then they'll move an application for 82 proceedings, 82 CRPC, Section 82. So
And
then
NBWs, I mean, it means non-bailable
non-bailable
warrants.
warrants,
Okay.
non-bailable warrants. And then once 82 proceedings are initiated, so this poster will come out, and his photographs and his warrants will be pasted outside the police station,
Oh,
outside court, outside his house, that
wanted.
we are not wanted, that this person is required. That wanted
Okay.
thing is it rarely happens, but it's in matters relating to national security, in
Okay.
terrorism cases, and you'll never see this person is wanted in this case. So that's another
Yeah.
cliche given to us by Bollywood.
We
So
learned this from Bollywood and Hollywood side.
that's not there. So coming back to the story, so I rang him up and he was like, "Do one thing, get the order and draft a bail there, then and there, and you should file it and make sure that it gets listed the day after, and argue it. You are going to do it." So I said, "Sir, I don't know. I'm not carrying my laptop or anything. I'll drive." So for the first time, I gave dictation. On very first day, I became a lawyer in a typing pool where there were hardly any computers, there were typewriters. In 2015, I'm telling you, it's not that back. So I got the bail ready and I got all the documents ready. I filed it and I got it listed before the sessions court. And by God's grace, then the very next day, I argued it and I got myself and my client a relief. And he was granted bail. So I was very happy. It was altogether a learning process. So the second day, of course, was very, I was very happy. But the previous day, on the day the bail was dismissed, I became more confident because the task there was to get the bail listed for the next day. And having nothing in my hand, I was able to do that. So that was the moment I realized I can do it. Of course, you just need to put in hard work and be and smart hard work, not jo, with no direction and nothing, just going
Not the
and
donkey hard work, but the smart
no, no, of course, I was trying to avoid it, but chalo.
work.
So that was my first case. And coincidentally, second case was NDPS.
Oh, okay. After that, it was in DPS again.
It was NDPS. It was in November, end of November, 25th November.
How do you
Uh,
guys remember the dates? I mean,
yeah,
I don't remember.
पहले के 4-5 cases की याद है.
Acha. Oh, it's just that. Okay.
Because
Brilliant.
it was heroin, 726 grams. It was commercial quantity. Judge was Mr. Arvind Kumar, Shri Arvind Kumar, learned special judge, and I got the bail on 7th of December. 25,000 का श्योरिटी बॉन्ड था.
25,000
The
surety bond
surety bond,
means.
surety, that's the surety. Whenever a person is granted bail, court says that you have to get the surety that if we'll release you, you won't run away. So that's a surety bond and a personal bond which every accused person has to produce before the court granting bail. So 25,000 की surety दिखानी होती, the soundness. In the event that person runs away, that surety, the person who's standing surety for that accused is bound to pay 25,000. And now He can even be he sent behind bars for I think 6 months. छः महीने तक का उसको imprisonment हो सकता है. I'm not sure about कि 6 में है या 3 है, but he can be imprisoned for 3 or 6 months.
Oh, okay.
हाँ,
Okay. Okay. That makes sense.
rarely happens. बस अगर कोई ऐसे भाग भी जाता है तो जो श्योरिटी अमाउंट है वो सीज हो जाता है, बट a provision is there. I'll have to
Okay.
look for the exact punishment. What's the punishment? But it's punishment and the seizure of the surety amount.
Oh, perfect. Okay. Cool. I mean, it's already heavy for us, Shivendra. We are just trying to make it more
And
simple.
if it's heavy, I'll try to make it more lighter because I'll be failing in my job if it'll be heavy for you and for the viewers.
No, no, you do your thing. I'll try to simplify that for the viewers. Okay. I just have one question out of all of this scenario, which is on one day you don't get the beat, on the other day you get it. How does that work? Was the on the honorary judge didn't have a had a good breakfast or something?
No,
How
no,
does
no.
that
It's not like that. It's not like that. I'll tell you. See, the day I did not get the bail, it was before ACMM, magistrate. All right.
Can you
And
explain
the
that?
very next day, I
What
see
is
it's a
that?
hierarchy of the court. I'll,
Okay.
I'll tell you. It's the hierarchy. It's very technical, but I'll tell you. I'll simplify it for the view for your viewers also. So in India, every criminal case has to be tried by the lowest court available. All right. I'll tell you about the metropolitan cities, and of course, I'll correlate with the states also. So at the very base, you have MMs, metropolitan magistrates. Then, superior to them, you have CMMs, chief metropolitan magistrate. There is only one in every district. MMs are, of course, there is an MM for every police station. So let's say if a district have 7 police stations, for example, you will be having at least 7 magistrates. And then one chief magistrate will be looking after the entire district, all 7 magistrates.
Okay.
Then uh, above that, above CMMs, you have sessions judge, additional sessions judge. That's in Delhi. I'm telling about Delhi right now. And
Okay.
sessions judge, and of course, districts and sessions judge. So district and sessions judge are at same level because additional session judge, additional sessions ASJ, and district session judge. The session judge is an addition to districts and sessions judge because there are so many cases. It is not possible, humanly possible, for one court to handle all those cases. There is another session judge who is in addition to it. So they are on the same rank, but the administrative powers. I'm sorry, what happened?
I don't know. I guess the laptop loved the conversation. It just shoots some
Okay, okay.
balloons.
Okay. So the administrative powers are more with the districts and sessions judge, whereas the judicial powers and the rank and the salary, of course, everything is same. Now come to states. There is a difference. There is JM1, Judicial Magistrate of Class 1, Judicial Magistrate of Class 2. It goes like this. And then Chief Judicial Magistrate. And of course, you have Assistant Session Judge. Then you have Additional Sessions Judge, Sessions Judge, and District Judge. So that is the hierarchy. And it is the law in our country that every criminal case, as I told you, has to be tried by the lowest court available. So the bail I moved that day was triable by the courts of judicial magistrate of first class.
Okay.
So the superior to that is assistant session judge. So the next day I moved my bail application. It's not an appeal, but for layman, it's easier to conceive it as it's an appeal because I was not granted relief there. So I went to a superior court to show my case that I deserve a bail. So on 12th of October, it was before judicial magistrate. Oh, sorry, it was before
The
CGM.
session said
It
CJ.
was before CGM, and the next date was before assistant session judge. So I got
Okay.
relief there. And at times, courts are not willing to exercise their discretion also. Because I told you, because that my client was a proclaimed offender. 82 proceedings were initiated against him. At that point of time, it was not a separate offense. Today, it is a separate offense. If someone is declared as proclaimed offender, there will be another FIR against him, that you're running away from law.
So you
170,
stabbed over someone, one FIR, and then you're running another FIR.
another. Now,
Okay.
earlier, it wasn't the case. So court was reluctant, and you already were avoiding the due process of law. So what's the point of granting you bail? You'll run away, and of course, you'll tamper with the evidence. You won't let the trial begin and everything. So court was of that view, but the Superior Court, I showed my case there, that even if the case of the prosecution is taken on its face, on its merits, there are technical flaws, and I deserve the benefit. And of course, the very golden principle that our country's criminal jurisprudence work on: you are innocent unless proven guilty, and onus is
Yeah.
upon the state to prove it. And so for that, trial has to be there. So I was able to
Okay.
secure. So
Okay. Okay.
it's
Because
not that the judge was not adhering to my arguments, or was not taking my arguments into consideration or like that. He had his own perspective, and he was trying to save his presence, the accused's presence for the trial. So he was right in his opinion. The Superior Court, which granted me relief, was right. It concurred with my point of my opinion, concurred with my argument. So that
so
happens. You
okay.
cannot say that the inferior court or the subordinate court is not, in its senses. There will be matters where you won't get relief from district courts, and of course you'll get relief from the higher court or high court or supreme court. You cannot say the subordinate court has not applied its judicial mind. It's never the case. There is a difference of opinion and the interpretation of law.
So it's about you have to basically convince the judge using law and the technicalities and the interpretation of law. I learned this word, the interpretation of law. So you do use all of this to convince the judge that what you are saying should be done, whatever it is. Yeah.
Yeah, it's
Okay. Kind of.
kind of that. Yeah, not
Okay.
exactly that, but yeah, there are a lot of things you have to show that there is a, if let's say we are raising a legal proposition, we back it with the judgment of a honorable Supreme Court, that the Supreme Court has also said this, that this is the correct interpretation of law. It'll be
Okay.
easier if I tell you by the example, I believe.
Yeah. Yeah. Please. Please. Please.
uh, let's say I am arguing a matter, a 420 matter. Everyone in our country knows what the
What
420
400 pieces? Yeah.
420 है. हालांकि सबको बिल्कुल गलत डेफिनेशन पता है, बट मोर और लेस वो जानते हैं 420 क्या
Okay.
होती
First, you tell us what is wrong about it. You tell us what's right.
है. It'll be way too technical. You'll have to know what 415 is. Of course, it can be a podcast in itself. So
Oh.
मैं आपको थोड़ा सा brief में I'll tell you.
Sure.
See, 420, if someone has committed an offense, he has cheated, and by cheating, I mean that he has done some overt act, or made someone do some act by which he has gained a wrongful, or by wrongful means he has gained some money or some undue advantage, or cheated of someone of some money. So there is a definition, 415, section 415, there's a definition. तो उसको cheating में बोलते हैं, and the punishment is in section 420. So
Okay.
always in criminal cases, we charge the person where the punishment has been defined. Okay, not the section where the definition is there, but the section where the punishment is there.
Okay. So the definition is in 415 and the punishment is in 420.
4 16, 17, 18, 19 are in the same context. All right. They on it's the same chapter, and what other things are defined. For example, 302 is the punishment for murder. The definition you won't find in 302.
Oh, okay. Now I'm getting it, I guess. So, uh, when you say ki he's a 400 BC, that basically means he's a 415 or something, because
हाँ,
the
फोर
punishment
फिफ्टीन
is in
सिक्सटीन और हाँ
420.
ऐसे. So let's say there is an FIR, coming back to the point, let's say there is an FIR and only 420 FIR is there, and the maximum punishment there is 7 years. All right. So there is a guideline by Honorable Supreme Court of India that where there is an offense which is maximum punishable by 7 years, you police needs to, or the department investigating that, the agency investigating that offense needs to uh, give a notice to the accused person under Section 41A of CRPC. That requires that you will give him opportunity to put forth whatever he has to say. It's not the guidelines, not the act says, not the section says that even after giving 41A, police cannot arrest. It's not that. But you cannot directly arrest. First, you have to issue the notice. So let's say that there is a case where 420 is there and police is raiding my premises, or is looking for me, but no notice has been issued. So I'll approach the court and I'll say, I'm ready to join the investigation. I'm ready to provide whatever is required. No 41A has been issued to me. Or if I'm arrested, I'll tell that the no 41A was issued to me. These are the judgments by the Supreme Court which say so that's necessary. This is what section says. The interpretation is here. So on that's how all the arguments have one limb of the argument will be the judgments, the pronouncement of the superior courts, be it if I'm arguing it before a sessions court or before a magistrate's court, it can be of our own high court or some other honorable high court or by honorable Supreme Court of India. So I have to, that will be the one limb of my argument. The other limb of my argument will be the factual aspect of the case, that how the case is not made out against me. Third limb of the argument will be what is my defense. Fourth limb of my argument will be what are the compliances which were necessary before making an arrest, which the arresting agency has not made, so it is bad in law. So all this, uh, these points come together, and then you are able to, in corroboration, you make an argument. So all these are steps towards making a case. You
Okay.
cannot argue only on one aspect. People do, lawyers do, but then of course that's not that's not always good enough, and you won't get relief much of the times, because whatever you are saying, whatever legal proposition, this is what I've been taught by my seniors. And of course, whoever joins my office, will be that my juniors or my interns, I tell them legal research is of paramount importance. Whatever legal proposition you are raising, either you are raising a legal proposition which has not been defined by the Superior Court or by the Honorable Supreme Court, then it's okay. Otherwise, you should back your argument by a judgment of a Honorable Supreme Court, preferably, if not by High Court.
So you take a reference of some judgment, the way you gave an example that, let's say, Supreme Court said that 41A has to be there to, do an arrest. Now it was not given. So you take the reference of
Yeah,
that judgment and prepare
of
your
course,
argument.
because whatever ratio has been given by Supreme Court, it in itself becomes law. It's a
Okay.
law. It needs to be followed. If very basic example, everyone would have heard about this judgment. कोई बहुत थोड़ा सा भी related होगा law से, सुना होगा अरनेश कुमार का judgment, Arnesh Kumar versus State of Bihar. That's there for offenses falling in the category where the punishment is less than 7 years or up to 7 years. So Arnesh Kumar needs to be followed.
Yeah, yeah, yeah.
तो
Okay.
वो फॉलो नहीं करेंगे, तो वो लॉ है जो फॉलो नहीं किया, वो डायरेक्शंस की तरह आता है. सी, लॉ इज नॉट व्हाट ओनली लेजिस्लेचर हैज मेड, उसको इंटरप्रेट करते हुए जो समझाया.
That's right. That's right.
लेजिस्लेचर ने तो एक्ट लिख दिया, एंड वो इस तरीके से लिखा हुआ है, बी दैट इन इंग्लिश और इन हिंदी, कि इट्स नॉट इजी फॉर अ लेमैन टू अंडरस्टैंड.
Right, right.
तो उसको जो इंटरप्रेट किया सुप्रीम कोर्ट ने या हाई कोर्ट ने, तो वो इंटरप्रिटेशन से जो जजमेंट निकल के आया, जो रेशो निकल के आया, वो रेशो भी लॉ बन जाता है, बिकॉज वो इंटरप्रिटेशन है लेजिस्लेचर का। इंटेंट क्या है लेजिस्लेचर का, दैट जुडिशरी टेल्स थ्रू इट्स इंटरप्रिटेशन.
Okay. Okay.
So it in itself becomes law. So that needs to be followed. And if it is not being followed, of course, वो फिर गलत है. That comes to your rescue of either side.
That's interesting. That sounds
Uh,
very interesting. I mean, how do you stay upright, Shivendra? There are so many things, so many laws, so many different kind of cases that might come to your
that's
table.
something one has to incorporate in their practice. If you're if you're in criminal litigation, civil litigation, whatever branch of criminal practice, civil practice, or I would say in general, whatever branch of practice you are in, you have to stay updated. You have to read judgments. You'll have to subscribe to law journals. There are a lot of electronic modes of journals today: Live Law, Bar and Bench, Manupatra, SCC. So of course, Legit Quest. I love Legit Quest. Legit Quest is there. तो इनसे अपडेट रहना हो पड़ता है. नोटिफिकेशन कम्स एंड ऑफ कोर्स, जैसे थोड़ा इजी हो गया है. पहले ओल्ड स्कूल देयर यूज्ड टू बी सब्सक्रिप्शंस. आई स्टिल हैव दोस सब्सक्रिप्शंस. यू गेट दिस वीकली जर्नल्स जिसके अंदर सुप्रीम कोर्ट के और हाई कोर्ट के सारे जजमेंट्स होते हैं. व्हाट ऑल इज सेड देयर, उसका ऊपर छोटा सा हेड नोट होता है. सो ऑफ कोर्स यू हैव टू रीड दैट. यू हैव टू पेन इट समवेयर टू रिमेंबर इट. अभी थोड़ा इजी ऐसे हो गया है. यू गेट अ नोटिफिकेशन एंड इफ इट्स समथिंग दैट यू कैन यूज, और इट कंसर्न्स योर प्रैक्टिस, यू कैन बुक मार्क इट आईपैड में या फोन में, जो भी. तो वो थोड़ा इजी
Okay.
हो गया है. बट आई लाइक इट जर्नल्स बेटर, बिकॉज उसको देखने के बाद वंस यू पेन इट डाउन, वो रह जाता है सबकॉन्शियस में एंड इट क्लिक्स. और वैसा
Right.
आईपैड पे नहीं है. I
Right. Right.
still
So,
I still prefer to make my notes by writing on the paper rather than using liquid text on my iPad. I don't like that.
yeah. 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 Great. Great.
Uh,
Okay. So, something for our viewers. Shivendra is a criminal litigator. Now, what criminal litigation
I
basically
would
means,
like
we'll
to
ask him.
I would like to correct you. I'm a criminal
Sure.
litigation practitioner,
Criminal litigation
criminal
practitioner.
defense
I
lawyer.
take my words back. Criminal litigation practitioner. So let's
Uh,
understand what criminal litigation practitioner is
mhm.
and what do you guys do?
See, majorly I practice on defense side. I am a criminal defense lawyer. If to be specific, I most of my cases are on the defense side. See, in every criminal case, one need not to be a complainant. States, whether be it in Delhi, will be, of course, Delhi government, GNCTT. In UP, they'll be UP. So states fight their cases in every criminal case for you. Let me
That
break down.
means
Let's say if A person is stabbed by B, all right, that person survived, but 307 is there, 307 IPC. Now, this A person does not want to file a complaint. Okay. Still, there will be an FIR against me by the state
automatically.
automatically. If complainant, the victim wants to be a complainant, very good. Otherwise, a police officer himself can be a complainant, that I have inquired and I have investigated that this person was stabbed. I have collected CCTV. I have other witnesses. I have apprehended B. I found a knife in his possession. I wrote his disclosure statement. On the basis of that, the motive came out. I took statements of the other witnesses, and on the basis of these facts, I'm filing my charge sheet. There is ample evidence. After filing of charge sheet, still that victim is not required. The entire burden of proving that offense against B will be taken care of by states, or
Okay.
in state in general. I'll talk about the entire country. By state, we mean every government.
Okay. That means they are there to prove that this person stabbed him.
So they'll take care of a criminal case.
Okay.
Similarly, if there is a mass cheating and no one wants to step forward, they are scared or whatever the reason may be, but it has been discovered by income tax department or CBI or ED, they'll investigate, they'll register an RC or FIR, and of course they'll investigate and collect all the evidence and they'll charge sheet that person, and that all that proceeding, that prosecution will be taken care of by the state. For state, there'll be a prosecutor, public prosecutor. So one side is clear. There are two sides. Generally, there are two sides. All right.
Okay.
So once there is a prosecution and there is a defense. Now, third side can be if complainant wants to join, if see, the complainant wants to be, sorry, a victim wants to be a complainant. He can, of course, hire his own counsel and, of course, assist the public prosecutor, but cannot per se directly address the court. He can
That
only
public prosecutor will do.
that the public prosecutor. Whatever the offense will be, every criminal case will be taken care of on behalf of state by the public prosecutor. State will take care of it. Complainant cannot advance arguments even before the court. They'll have to seek permission from the court to assist the public prosecutor. So
Oh,
that's
okay.
there in the Criminal Amendment Act of 2008. Of course, we'll have to see what the new law says. But as of now, complainant cannot. So that's one side. The other side is, of course, defense. So that's where I majorly practice. Of course, I have represented complainants and states and some matters, but mostly I practice on defense side. So for defense, there are a lot of things. As I told you earlier, also in our country, except otherwise provided by a specified act, a special act, every law works on a very basic principle that the onus of proving the guilt of the accused person is on the prosecution. It is incumbent upon the prosecution to prove its case beyond reasonable doubts. And I repeat it again, beyond reasonable doubts. So during, let's say there is an FIR. Of course, from FIR till that charge sheet is filed, and of course, when the trial is commenced, then the trial takes place, and of course, then there is acquittal or conviction. There'll be multiple stages. So what needs to be done at an appropriate stage? What law needs to be complied with? For example, the moment charge sheet comes, all right, we can argue in a CBI ED matter, in jurisdiction issue, we can argue that the CBI did not have the jurisdiction per se to file charge sheet in the court. They are filing it. The offense took place somewhere else. All right. That of course can be one argument of let's say another example. A charge sheet is filed in a 302 case. There's a murder case, and of course, charge sheet will be filed first before a magistrate. A magistrate will see the file is in order, everything is there, and then of course, because that offense is triable by the courts of session, they'll commit the file to the sessions court. But before magistrate, 207 CRPC needs to be complied. And what 207 CRPC says that every document which the prosecution, the investigating agency is filing on record, a copy thereof needs to be supplied to the accused person because they should know what's the case against them so they can
Hmm.
defend themselves. So let's say, for very basic, एक charge sheet में there are 500 pages. फाइल कर दिया MM के पास. Now we move in. Of course, copy was supplied to the accused person, but we scrutinized the file and we saw some of the papers are illegible or कुछ statements नहीं है. So we'll file 207 application before the court. These are the papers which are illegible and these statements are missing. And of course, we need the copy of these statements and these relevant documents. A reply then will be sought from the prosecution in consultation with the investigating officer will file the reply or supply the copy. So this is there. एक ये
Okay.
stage हो गया. ऐसे ही कई सारी stages होती. This is just one example. Prior to that, apprehension when one comes into the knowledge that there is an FIR against him. Of course, there are two options: either to join the investigation, which means, of course, surrendering, or take anticipatory bail and then join the investigation. सो वो एंटिसिपेटरी बेल कब लगाना है, या ऑलरेडी अरेस्टेड है तो रेगुलर बेल कब मूव करना है, ठीक है, क्या केसेस हैं, लेट्स से अगर इन्फ्लुएंशियल कंप्लेनेंट है जो टेम्पर कर रहा है इन्वेस्टिगेशन के साथ, तो क्या एप्लीकेशन मूव करना है कोर्ट के अंदर कि इन्वेस्टिगेशन फेयर रहे,
Makes
मैनिपुलेट ना
sense.
करी जा सके, कोर्ट मॉनिटर्ड इन्वेस्टिगेशंस, ठीक
Okay.
है। तो ये सारी चीजें होती हैं, और किस स्टेज पे क्या करना है वो, आई डोंट, बहुत सारी बुक्स मिलेंगी, पर आई डोंट बिलीव वो कंपाइल किया जा सकता है। एवरी केस, एवरी क्रिमिनल केस इज डिफरेंट फ्रॉम अनदर। टू केसेस आर नेवर सेम, आइडेंटिकल फैक्ट्स, बट वो सेम नहीं होंगे, बिकॉज डिफेंस बदलेगा, विटनेसेस बदलेंगे, विटनेसेस के हिसाब से सी, क्रिमिनल केसेस मेजरली डिपेंड करते हैं क्रॉस एग्जामिनेशंस पे। अगर क्रॉस एग्जामिनेशन टुडे, आई थिंक आई स्पोक विद वन ऑफ योर कलीग्स अर्लियर इन अदर पॉडकास्ट on the cross examination, and I told him also it's a dying art. Aaj, right out of the law school, everyone wants to join some senior or join high court or supreme court directly. And to quote Justice Waziftar here, trial court lawyers are artists, whereas appellate court lawyers are just art critic. They are merely an art critic. So no one wants to do trial, और जो ट्रायल नहीं करते हैं तो फिर वो उतना एक्सपोजर नहीं होता है, क्रॉस एग्जामिनेशन समझना नहीं आता है, ज्यादा इंपॉर्टेंट ये है कि क्या नहीं पूछना है विटनेस से, रादर देन नोइंग व्हाट टू आस्क। सो ये सब कलेक्टिवली काम करता है। सिर्फ आप एक क्रॉस एग्जामिनेशन स्क्रिप्ट बना लो, दैट दैट वोंट हेल्प यू इन एनी वे, बिकॉज वो विटनेस टू विटनेस चेंज करता है। इफ आई एम क्रॉस एग्जामिन यू फॉर एग्जाम्पल, आप मेरे किसी एक क्वेश्चन पे किसी अलग तरीके से रिएक्ट करोगे, और एक और अलग इंसान किसी और तरीके से रिएक्ट करेगा। सो इट हैज़ टू बी इन माय माइंड कि अगर मेरा ये वाला विटनेस फेल करता है जिससे मुझे ये इस्टेब्लिश कराना है, तो हु विल बी माय बैकअप विटनेस, जो लिस्ट ऑफ विटनेसेस दिए हैं प्रोसिक्यूशन ने। सो क्या आप मेरे अगेंस्ट आके डिपोज करोगे, मुझे क्या पूछना है क्या नहीं पूछना है, कि मैं पूछूंगा तो क्या एक्स्ट्रा आ जाएगा। सो एवरीथिंग needs to be done collectively, and it comes with practice. इसका कोई हैंडबुक नहीं है, and the moment charge sheet is there, I advise it to youngsters. The moment charge sheet is there, start building your defense from there on, because पांच छह विटनेसेस हो जाएंगे, देन यू विल स्टार्ट थिंकिंग अबाउट समथिंग, और दो विटनेसेस हो जाएंगे, देन यू विल इम्प्लीमेंट। द मेजर पोर्शन तो ट्रायल का चला गया, यू वोंट बी एबल टू
Mm-hmm.
प्रूव एनीथिंग, यू वोंट बी एबल टू establish what you want to establish. So building defense out of prosecution case, it's very important, and it's elementary. इट स्टार्ट्स फ्रॉम द वेरी बिगिनिंग, और उसी के बेसिस पे होता है कि किस स्टेज पे क्या एप्लीकेशन मूव होगा या क्या स्टेप लिया जाएगा।
It's a science, basically, as you said that
या
there are some gaps in charge sheet. You read through it.
it's more human psychology. Trial is more human psychology. Trial is not, criminal trial is majorly cross examination, which I'll quote again, as a dying art.
So
बहुत
is it
कम। Yeah,
the
it's a
the
dying
tr-
art,
the
because
uh-huh.
see, अगर करेंगे नहीं क्रॉस एग्जामिनेशन तो कैसे एक्सपीरियंस आएगा?
Right.
गलतियां नहीं करेंगे तो कैसे पता चलेगा क्या पूछना है क्या नहीं पूछना है, कब पूछना है कैसे पूछना है कुछ? क्रॉस एग्जामिनेशन क्रिमिनल ट्रायल में कभी स्क्रिप्ट से नहीं हो सकता है। जो करते हैं स्क्रिप्ट से क्वेश्चंस लिख के कर लेते हैं, दैट्स रॉन्ग, बिकॉज इट्स ऑल ह्यूमन साइकोलॉजी। आप किसी विटनेस, कोई विटनेस आपके किसी क्वेश्चन से एजिटेट होगा, कोई बहुत काम रहेगा, ठीक है, कोई एजिटेट होकर कुछ ऐसी बात बोल देगा जो उसे नहीं बोलनी चाहिए थी, लेकिन कोई विटनेस काम रहते हुए आपके क्वेश्चन में एक अपनी बात और घुसा देगा, जो उसके केस में पहले नहीं थी, लेकिन अब उस बिकॉज उसके काउंसलिंग ने बोला कि ये प्लग इन करना है हमारे को, लेक्यू ना, तो वो कर देगा। तो उसके लिए यू हैव टू बी वेरी वेरी फोकस्ड एंड यू हैव टू बी वेरी अटेंटिव। और वो प्रैक्टिस करने से आता है, उसका कोई हैंडबुक नहीं है। और
राइट।
अब जो यंग लॉयर्स हैं जो आ रहे हैं लॉ स्कूल से, कोई आना नहीं चाहता ट्रायल के लिए। एवरीवन वांट्स। अब हमारे ऑफिस में भी अगर कोई आता है, सर हाई कोर्ट में क्या है, सर सुप्रीम कोर्ट में क्या है, दे डोंट वांट टू गो टू ट्रायल। उनको दे आई डोंट नो, दे लुक डाउन ऑन इट और समथिंग लाइक दैट, आई डोंट अंडरस्टैंड। बट वहां पर क्रिमिनल लिटिगेशन में अगर आपको ट्रायल आता है, यू कैन बी, यू कैन अचीव एनीथिंग। और
So
उसके
trials happen somewhere else. I mean, it doesn't happen in high courts and the
of
upper
course,
courts.
the cross exam, the trial takes place in the district courts in criminal cases.
So it's like that,
जैसे
you know,
मैंने आपको बताया ना,
someone
because
is standing
every
somewhere
case needs to be tried by
at
the
the lowest court.
lowest court. तो हमारे जितने ऑफेंसेस हैं वो सारे खत्म हो जाते हैं, कवर हो जाते हैं डिस्ट्रिक्ट कोर्ट। तो हाई कोर्ट हमारा बचता है सिर्फ और सिर्फ एपेलेट। ओरिजिनल साइड क्रिमिनल में नहीं है हाई कोर्ट के लिए, अपीलेट जुरिस्डिक्शन रहती है हाई कोर्ट की। तो वहां तो जो अपीलेट में आया वो तो सारा ट्रायल तो हो गया ना, एविडेंसेस हो गए, आर्ग्यूमेंट्स हो गए, और जजमेंट आ गया। तो नाउ तो यू जस्ट आर्ग्यू कि ये जजमेंट नीचे वाली कोर्ट ने किस पॉइंट ऑफ लॉ पे गलत दिया, इस पॉइंट ऑफ लॉ पे सही किया। बट हाउ द केस वाज बिल्ड, वो फोर्ट्रेस बना कैसे, वो बनाना आना चाहिए ना।
That makes sense. Makes sense. Makes sense. Okay, so it happens the way, of course, not the way that they show in movie, but it's just that, you know, you ask a question and there's an answer and you're waiting for key. Now he will say something that, you know, that will build my case.
नहीं, ऐसा नहीं है।
Okay.
सी, मैं एग्जाम्पल से आपको बताने की कोशिश करता हूँ। 30, ये जो एग्जाम्पल लिया कि ए को स्टैब कर दिया बी ने, एंड ऑफ कोर्स वो केस रजिस्टर हो गया, एफआईआर रजिस्टर हो गया, चार्जशीट है। और लेस से उसमें 10 विटनेसेस हैं। तो वो 10 विटनेसेस जब आएंगे, वो 10 विटनेसेस के आगे चार्जशीट में लिखा होगा कि विटनेस नंबर 1 इस फैक्ट को प्रूव करने आएगा, 2 इस पर्टिकुलर फैक्ट को प्रूव करने आएगा, ऐसे करके कि 10 विटनेसेस क्या प्रूव करने आएंगे। तो लेट्स से पब्लिक विटनेस 3 है, वो स्पॉट पे जब उसने स्टैब किया, उसको बी ने एक को स्टैब किया, वहां पे 4 विटनेसेस, 3 विटनेसेस थे जिन्होंने ये देखा, जो आई विटनेसेस थे। तो उनका स्टेटमेंट रिकॉर्ड किया इन्वेस्टिगेटिंग ऑफिसर ने। ऑन द बेसिस ऑफ दैट दे विल कम एंड डिपोज इन द कोर्ट। जब उनको बुलाया गया कोर्ट के अंदर अपना टेस्टिमनी देने के लिए कि क्या हुआ था बताओ, लेट्स से उसमें से एक विटनेस हॉस्टाइल हो गया, उसने कुछ नहीं बताया कि नहीं ऐसा कुछ हुआ नहीं था, या मैं वहां था ही नहीं, फॉर वट एवर रीजन उसने नहीं किया। बाकी 2 विटनेस हैं, उन्होंने बोला कि बी आया, इनका कन्फ्रंटेशन हुआ, कोई आर्ग्यूमेंट हुआ, एंड देन ही टुक आउट अ नाइफ एंड ही स्टैब्ड इट। ठीक है, एक ही स्टेटमेंट है। उससे पहले हमारे पास चार्जशीट में इन्वेस्टिगेटिंग ऑफिसर ने ड्यूरिंग द कोर्स ऑफ इन्वेस्टिगेशन क्या स्टेटमेंट रिकॉर्ड किया है, वो भी होता है, और 161 स्टेटमेंट। जो दूसरा विटनेस है उसने आके बोला कि वो आया और इनके बीच में कोई आर्गुमेंट हुआ, वो वापस गया, फिर ना एक चाकू लेके आया गुस्से में और फिर स्टैब कर दिया। 2 अलग स्टेटमेंट्स हो गई, देयर आर
There are
टू
two
स्टेटमेंट्स।
arguments, two
आपको वो
separate.
स्टेटमेंट 161 के आइडेंटिकल मिलेंगे, बिकॉज ऑफ कोर्स दिस गोज अगेंस्ट द प्रोसिक्यूशन केस ना, कि 2 डिफरेंट वर्जन आ रहे हैं। सो मोर और लेस आपको सेम मिलेंगे। लेट्स नॉट गो इनटू इट कि क्यों सेम मिलेंगे, बट सेम मिलेंगे। ठीक है। और वो स्टेटमेंट अब आपके पास आए, अब 2 अलग स्टेटमेंट हैं कोर्ट में, और आप वो विटनेस को क्रॉस एग्जामिन कर रहे हो, तो आपके दिमाग में बैक ऑफ द माइंड होगा कि पहले तो ये नाइफ रिकवर हुआ था, ये केस है प्रोसिक्यूशन का। ठीक है। अगर मैं ये इस्टेब्लिश कर दूं कि ये नाइफ नहीं था इसके पास, और ये जो बता रहा है जिसने नाइफ मारा, उसने नाइफ किस तरीके का मारा, ठीक है, वो एक पार्ट हो गया। दूसरा पार्ट जो 2 अलग चीजें हो गई कि एक तो सडन प्रोवोकेशन पे मार दिया, एक वो उस सेंसेस में था, उसको कूल ऑफ पीरियड मिला अपने माइंड को करने का, वो गया और वापस लाया, उसमें क्रॉस एग्जामिनेशन करने का स्कोप आ गया। तीसरा, जब वो इंजरी हुई, ऑफ कोर्स वो उसका मेडिकल हुआ, वो मेडिकल ओपिनियन आया। आपको 99% लॉयर्स नहीं क्रॉस करते मिलेंगे इसके ऊपर, मेडिकल जूरिस्प्रूडेंस पे, कि भाई ये नाइफ से इंजरी पॉसिबल है कि नहीं है। अगर
Hmm.
ऐसे स्टैब किया जाएगा तो इस एंगल में ये इंजरी हो सकता है, नहीं हो सकता है, इससे ब्लड लॉस होगा नहीं होगा, इससे कौन सा पार्ट डैमेज होगा, ठीक है, कितना डीप जा सकता है। सो ऑल दैट यू विल स्टडी इन मेडिकल जूरिस्प्रूडेंस, जो हम 99% लोग नहीं पढ़ते हैं। 80% क्रिमिनल लॉयर्स के ऑफिस में वो आपको मिलेगा भी नहीं बुक। बट वो इम्पॉर्टेंट है, एक्सपर्ट विटनेस है, तो उसके सेंसेस में क्रॉस एग्जामिनेशन एक्सपर्ट विटनेस को करना, एक्सपर्ट विटनेस से क्या चाहिए था, क्या आ गया, फिर इन विटनेसेस को पूछना, तो वो सब आपको इंटरलिंक करना पड़ता है। यू हैव सीन दोज बोर्ड्स, CSI, और उसके अंदर एवरी डॉट्स ऐसे कनेक्ट करते हैं जो,
Right, right.
सो इट्स ऑल दैट, यू हैव टू डू इट इन योर माइंड। सो आपको करना पड़ता है वो, कि यार ये विटनेस, एंड देन ऑफ कोर्स यू नीड टू बी वेरी श्योर कि आई विल टेल यू द रियल थिंग व्हिच वी डू। ये विटनेस आज स्ट्रांग है, ये विटनेस को आज क्रॉस एग्जामिन नहीं करना है, क्योंकि ये बहुत रटा रटाया प्रिपेयर्ड विटनेस आया है, और इसकी टेस्टिमनी के साथ थोड़ा सा खेलना है। इसकी टेस्टिमनी नहीं है, ये इसके बाद हमारे पास बैकअप नहीं है, तो वी ट्राई कि इसकी डेफर हो जाए, ताकि इसकी थोड़ी सी, थोड़ा ऑफ कोर्स होता है ना, आज हमारे को जो चीज़ बहुत अच्छे से याद है, ज़रूरी नहीं है 10 दिन
कल भी
बाद
याद
वो याद
रहेगी।
होगी
Right.
उतनी अच्छे से। तो वो थोड़ा सा स्कोप बनता है, थोड़ा सा, फिर कॉन्ट्रडिक्शंस आती हैं, कन्फ्रंटेशंस आती हैं, वो सब प्लग करने का, बायसेस रखने आते हैं कि बायसेस हैं इसके, इसका इसका बायस किस पॉइंट पे है। तो वो सब यू हैव टू डू, एंड
Oh
ऑफ
my
कोर्स
God,
ऑन द
this
स्पॉट होता है,
is
उसके लिए कोई स्क्रिप्ट नहीं
bone chilling. Yeah, this discussion is bone
हो
chilling. I love
सकता।
it. Yeah, yeah. Please, please continue. Sorry.
सो वो आपको सब स्पॉट पे करना होता है, उस समय जिस समय आप कर रहे हो वो सारे डिसीजन, जैसे बोलते हैं ना कि ग्राउंड जीरो पे क्या डिसीजन ले रहे हो, वो आपको उसी समय डिसाइड करना है। ऑफ कोर्स इंस्ट्रक्शंस आपके दूसरे हैं, ऑर्डर्स आपके दूसरे हैं, सो आपने जो डिसाइड किया है, दैट्स ऑल इज देयर, बट एक्चुअली में उस समय क्या करना है वो आप उसी समय असेस करते हो, डिपेंडिंग अपॉन कि किस तरीके से इस विटनेस की टेस्टिमनी जा रही है। एट टाइम्स
Right.
बहुत बार ऐसा होता है कि मेरे को लगता है कि विटनेस इज गोइंग टू स्ट्रांग एंड ही वोंट गिव मी व्हाट आई वांट, सो आई ट्राई कि ये या तो डेफर हो जाए किसी बात पे, ठीक है, तो हम उसमें से लीगल रीजंस निकालते हैं कि नहीं, दिस डॉक्यूमेंट इज रिक्वायर्ड, या ये नहीं, या कुछ भी वटेवर, या हम उसको उस पॉइंट पे ले जाके छोड़ते हैं कि ये उसका क्रॉस खींचने के लिए, कि उसके टाइम ना बचे तो हम उसको नेक्स्ट डेट के ऊपर ले जाएं, कोर्ट आवर्स एग्जॉस्ट कर दें, तो हम उसको और एस्पेक्ट्स पे, जो हमारा मेन है, हर विटनेस का 2 या 3 पॉइंट्स पे ही होता है आर्गुमेंट, क्रॉस एग्जामिनेशन। उसके बाद तो सब इधर उधर की बातें हैं जो आप अपनी corroboration के लिए पूछते हो। हर विटनेस की सिर्फ 2 से 3 बातें, किसी ज़्यादा हद हो गए तो 4-5 हो जाएंगी, इससे ज़्यादा नहीं होती। सो देन वी ट्राई टू, वो नेट बनाने की कोशिश करते हैं कि ठीक है, वी आर नॉट गोइंग टू टच दी व्हाट्स देयर इन द मिडल, बट विल बिल्ड द नेट, विल बिल्ड द वेब, देन ऑफ कोर्स विल एग्जॉस्ट टाइम, एंड ऑफ कोर्स ये आएगा तो प्रॉब्ली इतना शार्प नहीं होगा, या मीनवाइल हम कुछ और कर सकते हैं, रिसर्च कर लेंगे, स्पॉट विजिट कर लेंगे,
Hmm, hmm,
लाइक
hmm.
उस स्पॉट से था नहीं था, अदर थिंग। वो नहीं करते हैं आज की डेट में क्रॉस एग्जामिनेशन से पहले प्लेस ऑफ इंसिडेंट जहाँ पे हुआ है ये एलिजिड ऑफेंस विजिट, वहां से कम 50 क्वेश्चंस बनते हैं, लेकिन कोई नहीं करता, किसी के पास
Right,
टाइम।
visiting the place where incident happened.
फिर the
We have
incident,
seen this happening in movies. Lawyers go with their assistant and then they
दैट इज वेरी
see.
इंपॉर्टेंट। पहले करते थे, ओल्ड स्कूल लॉयर्स करते थे, आज बहुत कम होता है, टू बी वेरी ऑनेस्ट, हर केस में मैं भी नहीं करता हूँ, बट जो फंसे हुए केसेस होते हैं, जो होते हैं ब्यूटीफुली इन्वेस्टिगेटेड केसेस आते हैं जो, तो उसमें करना पड़ता है, बिकॉज आप सी व्हेन देयर इज अ गुड केस इन फ्रंट ऑफ यू, यू हैव टू गो टू बेसिक्स, आपको सारे चेक बॉक्स पे टिक करना पड़ेगा अपने पार्ट पे, बट वो कैसे बिल्ड हो रहा है वो बदलता जाएगा, देन यू हैव टू असेस देन एंड देयर एंड टेक डिसीजंस।
Okay, okay, this is brilliant. I mean, we can do this for 5 hours, I believe. Uh, okay, so defense. Criminal litigation practitioner. Yeah, that's.
Close.
I'm
Close,
putting my
close.
words correctly.
Yeah.
Uh, Criminal litigation defense lawyer basically means uh, B stabbed A, you are defending B. Okay. Uh, and everybody in society, generally are like, why is he supporting that murderer or that rape accused or this, offender, or, all these things happen. I do
Mm,
this, everybody do this. Okay.
mm.
Uh, how do you think? How do your family see? Is there a case where the morality and consciousness was like, your family was like, no, don't do it. And then you did it and then something else came out of it.
Yeah, this happens very, very often. You won't believe. At times, I get threats on my social handles.
Oh, yeah, that was my question. You get threats.
Yeah, of course.
What
Because
kind of threats? Like
um,
serious.
serious threats, I won't go into it, but serious threats. Where is your office? We are sending someone to take care. I won't get into
Oh my
it, but
God.
of course there are threats. फेसबुक तो भरा हुआ होगा. आई डोंट इवन लॉग इन देयर. मुझे याद नहीं लास्ट मैंने कब किया था, बट whenever these kind of cases come, in fact sometimes victim family, ठीक है, वो करते हैं थ्रेट. कोर्ट में थ्रेट करते हैं, कितनी बार मिसबिहेव करते हैं, अब्यूज करते हैं. ऑफ कोर्स बार इज देयर टू प्रोटेक्ट अस. सी आई टेल यू, पहली बात, मेरे बार काउंसिल रूल्स, ठीक है, और एडवोकेट एक्ट, ये दो मुझे एम्पावर करते हैं हर एक इंसान को रिप्रेजेंटेशन देने के लिए. एंड बार काउंसिल रूल्स सेज डायरेक्टली टू द कॉन्ट्री, वी कैन नॉट से एनी लॉयर इन दिस कंट्री cannot say no to any person to defend their case only on the ground that he thinks he has done something wrong, or people think he has done something wrong, or a bunch of people or society think they have done something wrong. They everyone has a right to be legally represented, and that is a right which is guaranteed by the Indian Constitution. तो वो लीगल रिप्रेजेंटेशन का राइट कैन नॉट बी टेकन अवे. एंड आई कैन नॉट से नो, आई एम नॉट गोइंग टू. जो भी ये बोल रहा है और जो इस प्रिंसिपल पे काम कर रहा है, माई लाइसेंस कैन बी रिवोक्ड बाय द बार काउंसिल इफ आई डू सो. इफ आई एम सेइंग कि मैं नहीं आपको रिप्रेजेंट करूंगा क्योंकि मुझे लगता है आपने कुछ गलत किया है, दैट इज फॉर द कोर्ट फॉर डिसाइड, गो टू डिसाइड. इट इज नॉट अप टू मी. व्हाट आई कैन डू इज, या तो मैं उसका केस रिप्रेजेंट करूं या मैं ना रिप्रेजेंट करूं ऑन द ग्राउंड्स दैट आई एम नॉट अवेलेबल, या आई हैव सम अदर कमिटमेंट्स. दैट इज ओके. बट ऑन द ग्राउंड कि मुझे लगता है आपने ये किया है तो मैं नहीं करूंगा, दैट इज रॉन्ग. आई गिव यू अ वेरी गुड एग्जांपल. एक केस में, आई वोंट टेक नेम्स, बट आई गिव यू अ केस.
Sure.
देयर वाज दिस केस, अ पॉक्सो केस इन माय ऑफिस. इसमें क्या हुआ, एंड इट्स अ वेरी
POXO
इंटरेस्टिंग केस.
is the
पॉक्सो इज अ
child.
प्रोटेक्शन, हाँ जी हाँ जी, इट्स अ प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंसेस. It's a specific act which came into existence after, of course, Nirbhaya's case in 2013.
There are a lot of famous cases happened after that Asaram Babu
Of
case.
course, of course, lot of, not famous per se, but high profile cases.
Al-
Famous सही term नहीं होगा use
Yeah,
करना.
sorry, famous is not the right word, but yeah, high
हाँ
profile cases.
हाँ, बहुत हुआ, बहुत आया है इसके में कि ऐसे इसका हो रहा है. तो I'll tell you something. My wife is also a lawyer. She, in fact, is a public prosecutor,
Oh,
and she's a public prosecutor before Delhi High Court for GNCTD. Earlier, of course, we have our own firm. She was there in the office, and of course, there was this POXO case, and the victim was a school-going child of nearly 6.5 years. So, of course, the file came, and of course, it struck us कि भाई 6 साढ़े 6 साल की बच्ची है, and there is this case, and the brief the brief came, and I was like, कि things are not what it is being portrayed, the way they are being portrayed. तो of course जो केस लेके आए थे वो एक लॉयर की रेफरेंस से ही केस आया था, तो उनके साथ डिस्कस किया, And you won't believe, most of the associates in my office were like, "Sir, don't take this case. We are not finding conscience to do this case, please." Especially my female staff, they were not with me on this. But I said, "All right, let's do it. And if we'll find something like this, I'll leave this case. But trust me, it's far from what you're thinking." So what happened, that there was a this the allegations, I'll tell you first. The allegations were that this victim, this child, was going to school, uh, and she was going through school bus, and the conductor of the school bus assaulted this child. So these were the allegations. Okay. So of course, school people also came and told me that this is not possible. As I asked, is there any dispute going on between parents and you? And they say, of course, there is a dispute going on between the mother of the child and between the school administration on the fees issue. She wanted her child to be enrolled as a student under EWS, but the school was saying, no, we cannot do that. Whatever the
AW,
reason,
AWS is?
EWS, economic weaker section. I think there is
Okay,
this
okay. EWS.
classification
Yeah,
education
yeah, yeah.
system, where you, of course, you get बेनिफिट्स, वो फीस उतना नहीं देना पड़ता है, एंड ऑल होता होगा कुछ. सो ईडब्ल्यूएस डीप में इतना मुझे भी नहीं पता, बट ईडब्ल्यूएस
Yeah, yeah, okay.
वो है. सो ओके, एंड दिस सर, दिस इंसिडेंट, the way she's claiming, cannot take place because we have a policy. And so, what is the policy? How are you so sure? Said, because the moment school bus leaves our school in the morning, there are CCTV cameras in each and every school bus. The moment the bus leaves, the camera is switched on. The first person to get into the bus is a school teacher. The first person to get out of the last person to get out of the bus is a school teacher. So it's not possible. I said, okay, get me those CCTV footages. Okay. So while I was going through the CCTV footages, the allegations were of 22nd and 23rd December. The kid was not even in the bus. She was absent
On both the days.
on both the days. And somehow one of the teachers were involved in that, because she was present, she was marked as present in the school register, the attendance register.
Okay.
All right. So their case was that she is present because the attendance register says she is present, but she was not there in the school bus. So how can it be? So we, of course, made our case on the basis of that there is the school policy, and of course the allegations leveled were of 22nd and 23rd December. The entire day she was not in the school. She did not come to school in the school bus, of course, because she was not there, and she was not there when the school after the school, when the school bus was dropping off the children. So she was not there. So the allegation is of the incident which her mother say that took place in the school bus, and the only occasion where this kid could be in the school bus is either when she was coming or when she was going. So she's not there. Other thing, that how the attendance register is showing that she is present. Then the CCTV footages of the entire school were taken, and she was not to be found in the school. Not in her classroom, not in the corridor. Every child coming towards the classroom was, of course, can be seen in the CCTV, but this kid never showed up. So the mother was using this child to settle scores with the school administration. And this man spent good I think 2.5, 3 years in custody because of this case. And after that, he got bail, and case, of course, still going. So can you imagine the plight of the family, where a person who has an unblemished record of 30 years has been accused of something so heinous and who has not done that offense, what will be the plight of that family? A person spending around 2.5, 3 years in custody. Family, trust me, I spent on this case out of my pocket. The family was on the verge of starvation.
And the society's pressure is completely different on this.
Of course, that's there in I see. I'll tell you this. I'll of course I won't shy away, and I'll tell you this as a criminal law practitioner. And of course, one of my specialties being sexual offenses. ये जो टैग है ना एक्यूज के ऊपर से, this never goes
Never
away.
goes.
See, even if you are acquitted, this will be there because society के दिमाग में वो नहीं होता, कुछ तो किया होगा तभी तो ऐसे केस नहीं बना. सो ये जो आउटलुक है, दिस वेरी नोशन दैट दिस इज द स्टिग्मा दैट स्टेज. So of course he has to live with it for his entire life. His job is gone, children suffered, his wife suffered. He during this time he lost his father. Cannot be undone. So, and trust me, there are cases where people are using their children to settle scores, and there are cases where this has become a nexus. It is an organized crime, I would say. They are making traps to lure people in, and then they're mooching out money out of people. They settle
My
cases,
God.
and because of these kind of people, जो एक्चुअली में जिनके साथ गलत हुआ है, जो विक्टिम्स हैं, एक्चुअली में जो विक्टिम्स हैं, उनके केसेस भी ओवरलुक हो जाते हैं. बिकॉज ऐसे किस जुडिशरी को भी समझ में आता है यार, they can see what has happened. So they take decisions on the basis of law as well as on factual aspects. Because सिर्फ कह देने भर से ऑफेंस नहीं बन जाएगा ना, सिर्फ एलिगेशंस लगाने से नहीं बन जाएगा ना, वो फाइल पे भी तो कॉन्क्रीट होना चाहिए.
Even then, then in the society also discussion starts happening. No, कि
अरे
मतलब
हमारे
पता
यहाँ
नहीं
तो
सच है
बहुत
या गलत है. ये ऐसे भी डिस्कशन शुरू हो जाते हैं.
एक इंसान जो सेक्सुअल ऑफेंस के लिए अक्यूज बनाया गया है, उसके 3 ट्रायल्स चलते हैं. ये मैं बोलता हूँ. एक तो एक्चुअली में जो ट्रायल है जो कोर्ट में चल रहा है, एक सोसाइटी का ट्रायल चल रहा है, और एक मीडिया ट्रायल चल रहा है.
Right.
बाकी दो ट्रायल्स की जरूरत नहीं है, बट वो चलते हैं और वो एंडलेस है. उनका कभी कभी भी उन ट्रायल्स का एंड नहीं है, और डिसीजन नहीं है. डिसीजन ऑफ कोर्स है, एक अनसेट डिसीजन है, बट वो एंडलेस है. वो हमेशा रहेंगे. वो अपनी रेजिडेंस चेंज कर लेगा, अपना प्रोफेशन चेंज कर लेगा, अपनी जॉब चेंज कर लेगा, बट वो स्टिग्मा रहेगा.
Right.
और ये अब चेंज होना चालू हुआ है बिकॉज हमारे लीडर्स ने हमारे एज इन फ्रॉम प्रोफेशन, आई एम सेइंग, आई एम नॉट टॉकिंग अबाउट द गवर्नमेंट, हमारे जो लीडिंग एडवोकेट्स हैं और जो जूरिस्ट हैं, उन्होंने ये लिया कि जो आइडेंटिटी प्रोटेक्ट आप सेक्सुअल ऑफेंसेस में विक्टिम की कर रहे हो, वो जरूरी है कि आप एक्यूज की भी करो.
Accused की भी करो. Right.
तो आप उसका नाम तो वो हो गया पब्लिक, उसने नहीं किया बट वो रहेगा. सो इट इज़ वेरी इंपॉर्टेंट. सो देन दिस pronouncement from the Supreme Court also came. You have to protect the identity of the accused also. अभी पूरे तरीके से नहीं हो रहा है, but of course एक initiative है which is much appreciated and it should be done.
Yes, we have a lot of examples. I won't say a lot of examples, but there are a few examples that we see on social media also.
Of course, the
Something
social
else
media
happened
is,
and the girl got in for something else, and
sir,
then
social media is full of these kind of cases. There are honey traps.
yeah,
जो डेटिंग एप्स वगैरह पे चल रहे हैं, हनी ट्रैप्स हैं. ठीक है. और दे डू एक्सीलेंट ट्रैकिंग. ठीक है. they'll बी नोइंग एवरीथिंग, क्या बिजनेस है या क्या प्रोफेशन है, क्या जॉब है, कितना सैलरी है, क्या. तो प्रॉपर उसके हिसाब से वो टारगेट करते हैं. ठीक है. देन ऑफ कोर्स ये मनी एक्सट्रैक्ट करते हैं आपको ट्रैप करके. उसके बाद आप आजकल लोग इतने ज्यादा, स्पेशली जैसे मैंने एक एग्जांपल दिया, ये एक एग्जांपल है, ऐसे बहुत सारे केसेस. आई हैव अ केस वेयर द एलिगेशन फॉर Rape came after 22 years. I have a case where the woman says that this person has assaulted me for 22 years. And while these 22 years, she was married with her to someone else, had 3 kids. She was going out, partying, meeting people, living all her life. Okay? But still, she was under threat, God knows of what, that he is being against my, because there was this extramarital affair going on between the parties. And she was, of course, getting a good amount of money. ठीक है, मेंटेनेंस एक तरीके से कह सकते हैं, he was looking after her expenses. But now, because he wasn't into her, or he does not want that relationship to continue, this FIR came into existence. 1 साल के आसपास कस्टडी में रहा ये आदमी, ये अक्यूज्ड, ठीक है, जिसके 2 बेटे हैं. एक बेटा वॉज इन स्कूल और एक बेटा इज बेड रिडन, ही कैन नॉट गेट अप ऑन हिज फीट. वो इतना ज्यादा मेडिकली चैलेंज्ड है, टेक केयर करने के लिए और घर में कोई है नहीं. और ये 1 साल के लिए था इस केस के अंदर. एंड यू वोंट बिलीव, the husband of the lady, he came in as a witness and said, nah, my wife was having sexual relationship with this guy. I know that. And the threat perception which came, कि now I'm raising my voice, जो explanation आया after 22 years, is because now this man wants to have relationship with my daughter. Nothing else. And in that 22 years, we, of course, filed the transactions in the court. This guy had spent over 50 lakhs on this woman.
50 lakhs.
Over 50 lakhs for, of course, maintaining her and
Meant
looking after her expenses and घर के उसके expenses, because वो थोड़े जो उनके husband हैं, he's into alcohol and everything. He was not looking after his family, so that's how this relationship started. बट जब तक पैसा आ रहा था, जब नहीं आया उसने मना कर दिया कि नहीं, नाउ आई वांट टू टेक केयर ऑफ माय चिल्ड्रन, बिकॉज वन इज इन स्कूल और दूसरा का वो बेड रिडन हो गया है, वो उसके आई हैव टू टेक लुक आफ्टर मेडिकल एक्सपेंसेस एंड एवरीथिंग. Case came into existence. And while doing this case, we came across a case जिसके अंदर ये this very lady had filed a case one other man where earlier she was working, and she settled it in crores.
same lady.
The same lady, the very same lady, identical uh, allegations उसी तरीके से. And we filed the judgment, and of course her statements given in that case before the concerned court in our matter, हमने certified copies निकाल के file करे थे. She is a habitual complainant, she's a habitual litigator, and she is extorting money. So that's how we were able to secure acquittal in our case. एंड उस केस के अंदर आई डोंट नो कितना सच कितना झूठ, द सेटलमेंट टुक प्लेस. ऑफ कोर्स देयर शुडंट बी अ सेटलमेंट इन 376 केसेस, द लॉ सेज अगेंस्ट इट. बट सुनी सुनाई बात जितनी आई हमारे हमारे तक पहुंची कि उसने करोड़्स में सेटल किया है केस.
My God.
ऐसे भी लोग हैं जो ऐसा
My
पैसा
God.
एक्सटॉर्ट कर रहे हैं.
A great startup. Not a great startup, but rather not a great
It's
startup.
not. It's
It's
not.
just so,
Trust
so
me,
bad.
it's
So bad.
not. अब because courts are very vigilant, आपको बहुत सारे हाई कोर्ट के ऑर्डर्स मिलेंगे जिसके अंदर हैबिचुअल लिटिगेटर्स जो होते हैं, जो हैबिचुअल कंप्लेनेंट्स होते हैं, उसके बारे में कोर्ट अगर एक भी केस और है नॉलेज में आ जाता है तो कोर्ट बोलती है सीधा डीसीपी को एक एप्लीकेशन जाता है कि गेट मी द कॉपीज ऑफ द केसेस व्हिच दिस पर्सन हैज फाइल्ड. So then, of course, modus operandi निकल के आ जाता है, and then courts are taking action against such people. So not a great startup, I would suggest.
Yeah, yeah, no, not a great startup. Yeah, yeah, yeah.
Uh,
I thought I will ask you some outrageous cases, but you already came with two. I don't think that I can handle few more because. And do you think? I mean, yeah, okay. There are these two examples. But there are other examples, as you also only said, that there are genuine cases also
Of course,
that are
there
there.
are.
A lot of them.
Of course, there are. I did this acid attack case. We represented it. Came out to be a true incident. We fought tooth and nail for our, of course, we represented our client to the best of our ability, I would say. But we were we weren't disheartened by the outcome of it because they were convicted in the trial court, they were convicted by the High Court. And of course, by the appeal is coming before the Honorable Supreme Court, 100% they'll be convicted. There are very few moments where my heart is wrenched. And while I was arguing that matter before the Honorable High Court, this lady who was the victim of that acid attack, she came to attend that proceedings, and she, during the course of proceedings, she took permission of the court and she unveiled herself. And I have a very strong heart. I do cases which takes a good strong person and takes a strong hearted person.
Sure.
But in that very moment, I felt, yeah, I'm going to give my best, but I'm not going to be disheartened by the outcome, even if they are behind, because they actually did it. It was, you can say it was a love story gone bad and honor type killing type of thing. Cannot be termed as honor killing because, of course, she survived, but it's worse than getting killed. So that's one example. And there are cases where it turns out that, of course, our client has done it. And see, our job is to give a 100% genuine representation, legal representation to our clients. Of course, relief matters in the end of the day, but not in each and every case. We That is the other thing which young lawyers should learn and should incorporate in their practice. Be professional. Don't get too attached to a case or too personally involved in a case, because when you start doing that, you tend to make decisions which you will regret. And that is going to harm you in a worse way than you can imagine. When you get yourself personally involved in a case, you tend to say things which will 100% will come back to you. You at times get irritated and say some things to the opposite counsel. At times you say something to the judge, which of course is not good. And when you get personally involved, you spoil your practice because you will not be able to focus on other things, other aspects of practice. So it is of utmost importance that be you keep yourself professional to the core, and do not, of course, give 100% genuine representation to the best of your ability, but don't associate yourself, don't put yourself in the shoes of your client. One should never do it. राइट वो मूवी है ना, बहुत क्लीशे चीज है, कौन सी मूवी है वो, दैट संजय दत्त मूवी, मुन्ना भाई एमबीबीएस. सो उसमें बोमन ईरानी का दैट डायलॉग, दैट ऑफ कोर्स इफ यू विल गेट पर्सनली इन्वॉल्व्ड यू वोंट बी एबल टू डू योर बेस्ट. तो वो सच है, दैट्स ट्रू. एंड आई हैव सीन पीपल स्पॉइलिंग देयर प्रैक्टिस, पर्सनली इन्वॉल्व होकर प्रॉपर्टी केसेस में. दे डोंट हायर अ काउंसिल, और वो खुद करते हैं बिकॉज आई एम अ लॉयर, आई एम गोना डू माय केस माय सेल्फ. वो कोर्ट पे भी गलत जाता है कि ही इज गेटिंग टू मच इन्वॉल्व्ड एंड ही इज ट्राइंग टू पुल सम स्ट्रिंग्स, और ये डॉक्यूमेंट की जो वो रिलाई कर रहा है उसकी जेन्युइननेस क्या है एंड एवरीथिंग. सो ये सब है. सो पर्सनली इन्वॉल्व ज्यादा ज्यादा का
नहीं
बिल्कुल
होना चाहिए.
होना चाहिए यार. एक हद तक ठीक है, आप किसी किसी केस में मैं देखता हूँ कि हो जाते हैं पर्सनली इन्वॉल्व, ठीक है, वो भी एक हद तक, बिकॉज एट द एंड ऑफ द डे यू आर ह्यूमन, वी आर ह्यूमन. एसोसिएट कर लेते हैं अपने आप को उस सिचुएशन के साथ, विच इज बैड. सो बीइंग प्रोफेशनल, दैट्स
Right.
हाउ आई कीप माई सेल्फ सेम. And I think that helps me taking right decisions.
No, that's important. I mean, yeah, I mean,
That's very important. That's
sure.
what, unless, otherwise it'll get back to you. आपकी ही क्लाइंट्स आपके बारे में एक नोशन बनाना चालू कर देंगे, आपकी फर्टर्निटी आपके बारे में एक ओपिनियन बना लेगी. ठीक है, तो वो सब नहीं है अच्छा. यू हैव टू. अब मैं ये नहीं कह रहा हूँ कि आप सी, वे बहुत बहुत क्लोज लाइन है. अभी आप सोच रहे होंगे कि मैं आपको कह रहा था कि आप बार काउंसिल रूल्स बोलते हैं कि रिप्रेजेंट करो. दूसरे जगह मैं आपको बोल रहा हूँ कि प्रोफेशनल रहो. तीसरा, ऐसे भी केसेस होते हैं जहां हम आउटकम से नहीं इतना अटेक्ट.
Certain नहीं होते.
तो ये सारी चीजें बहुत बहुत थिन लाइन है इसके अंदर ना. और आपको उस वो बहुत ग्रे एरिया कुछ नहीं है. आपको
Right.
सेंटर में इक्विलिब्रियम से रहना है कि भाई जरा सा इधर मैं अनप्रोफेशनल, जरा सा इधर आई एम टू अटैच्ड. तो वो आपको मेंटेन करके रखना पड़ेगा. और वो जितना सुनने में लगता है डिफिकल्ट, उतना एक्चुअली नहीं है. आप अगर उसको हैबिट बना लो अपने प्रैक्टिस की, टेक हार्डली 6 मंथ्स. अगर आप वो एटीट्यूड के साथ परस्यू कर रहे हो, ये एक चीज मैं आई ट्राई टू टीच दिस टू माय स्टाफ, टू माय एसोसिएट्स, माय इंटर्न्स, एवरीवन. तो ये कोशिश करते हैं हम बाकी.
Well, that's, I mean, I trust me, I have no words. I can't even make a sentence right now. Uh, okay, okay. Let me come out of this. This was at some point was heart wrenching for me. Listening to both the things, both the scenarios. Um, a- and yes, I mean, even Kasab got a defense lawyer, if I'm not wrong. Nirbhaya case that happened. Uh, those guys got the defense lawyers. Everybody should get it because that's what Constitution says, and it is required.
See,
What this?
I'm cutting you
Yeah,
in
yeah.
good. I'll tell you one thing. There's something which everyone should know also. Even if a lawyer says that I'm not going to represent, let's, and the action, whatever in persons of law is taken, is being taken against that lawyers, वो चलो छोड़ दो, उसको आप साइड रख दो. Even if one says कि मैं आपको represent नहीं करूंगा, तो do you think कि वो उस accused को representation नहीं मिलेगा, legal representation?
Right.
It's not like that. The court out of its own expenses, state out of its own expenses, sorry, court will appoint a lawyer. लीगल एड काउंसिल हो सकता है. देर आर केसेस जहां पर अक्यूज बोल देते हैं कि आई एम नॉट इन अ फाइनेंशियल कंडीशन टू अफोर्ड अ लॉयर एंड आई वांट दिस पर्टिकुलर लॉयर, नाम के साथ बोल देते हैं कि ये वाला लॉयर चाहिए. तो कोर्ट अमाइकस बनाती है, और हम जो जिसको अमाइकस बनाया उसके एक्सपेंसेस वो स्टेट जो प्रोसिक्यूट कर रही है वही बेयर करती है.
Okay, so
या बिकॉज
any name.
any name I want, then of course court makes a letter of request कि this is the person, और ये ऐसा ऐसा case है, he wants, he's not in a financial condition, he wants you to represent him, and of course every request by the court is considered as a order. तो मना नहीं करते, कोई नहीं मना करता है. सब करते हैं वो केसेस अमाइकस बन के. सो अमाइकस जब आप बन रहे हो तो दोज एक्सपेंसेस जो आप इनकर कर रहे हो, ऑफ कोर्स देयर इज अ सेट अमाउंट ऑफ फी व्हिच यू कैन which you can claim from the state, but of course state will be bearing that expense. सो लीगल रिप्रेजेंटेशन तो उसे तब भी मिलेगा. लीगल रिप्रेजेंटेशन तो बहुत कोर है हमारे फंडामेंटल राइट्स का. सो नो वन कैन बी डिनाइड ऑफ अ लीगल रिप्रेजेंटेशन.
Someone will be standing with them.
समवन लीगल एड काउंसिल आ जाएगा, लेट्स से कोई नहीं है, और वो किसी का नाम भी नहीं ले रहे हैं, बोल रहे हैं कि आप, कोर्ट पहली चीज पूछेगी पहली डेट पे ही, आपके वकील साहब का है जी, हम तो कंडीशन में नहीं है, हमारे कोई वकील साहब नहीं है, आप अपने आप कर सकते हैं या हम आपको प्रोवाइड करा दें. सेकंड क्वेश्चन. और वो नहीं कर सकते हैं तो ऑफ कोर्स कोर्ट प्रोवाइड कराएगी. लीगल एड काउंसिल पैनल्स हैं जिनके जिनके फीस और जिनके एक्सपेंसेस स्टेट इनकर करती है, बेयर करती है. तो पैनल से रिप्रेजेंटेशन के लिए, तो ये नोशन, ये आउटलुक की लीगल रिप्रेजेंटेशन नहीं देना चाहिए, ये वही गलत है. बिकॉज लीगल रिप्रेजेंटेशन सबका मौलिक अधिकार है, तभी तो इतना सारा इंफ्रास्ट्रक्चर खड़ा किया है
Like these kind of
लेजिस्लेशन में,
thoughts ki,
और
you
उनके
just
लिए
shoot
कुछ
them on the roads and burn them alive and then hang them on the streets. These kind of notions that generally revolve when something outrageous happens
सर,
anywhere.
आई डिड अ मैटर वेयर आई गॉट some serious threats that the moment we'll see you, we'll shoot you. But will that make me back off from a matter? No, never. Because ये एक जनरल परसेप्शन है, ये बहुत, जो हमारे सोशल मीडिया पे लोग हैं ना, जो लोग हैं, कुछ लोग बहुत गुस्से में बहुत चीजें ऐसी बोल जाते हैं जो वो मीन नहीं करते हैं। मैं ये नहीं कह रहा हूँ कि ये सारी थ्रेट्स बोगस होती हैं, ऐसा नहीं है, बिल्कुल ऑफ कोर्स कॉशियस रहना चाहिए, मैं भी रहने की कोशिश करता हूँ। बट मेजॉरिटी जो है वो ऐसी बातें हैं जो आज जो उन्होंने कुछ मैसेज किया, उनको आई थिंक कल तक याद भी नहीं होगा, उनके पास कल कुछ दूसरा कोई मीम या कोई ट्रोल या कोई ऐसा न्यूज़ जिसके ऊपर उन्होंने रिएक्ट करना है तो होगा। तो मेजॉरिटी, और यहीं पे मैं ये बात बोलता हूँ कि इसीलिए बहुत इम्पोर्टेंट है कि हम हमारे स्कूल्स में, हमारे एजुकेशन सिस्टम में कुछ ऐसा स्टेप लें जिससे वो सेंस ऑफ रिस्पॉन्सिबिलिटी ऑफ व्हाट यू आर सेइंग एंड डूइंग, वो सेंस क्रिएट होने लग जाए। ठीक है, जैसे वो कुछ, ये एक ऐसी सेंस है जो सिखाई नहीं जा सकती। दिस इज अ स्किल, इट्स नॉट अ स्किल, इट्स समथिंग विच अ पर्सन विल लर्न ऑन इट्स ओन। बट कोई कोई एक ऐसा एजुकेशन सिस्टम में सब्जेक्ट नहीं होगा, बट ऐसा कोई एक्टिविटी डिजाइन किया जाए या कोई ऐसा मेडिटेशन या एनीथिंग जिसके अंदर वो सेंस ऑफ रिस्पॉन्सिबिलिटी कि मैं क्या बोल रहा हूँ और कब बोल रहा हूँ और क्यों बोल रहा हूँ, उसको असेस कर लो। ठीक है, पुराने जमाने में बोलते थे ना कि सोचना चाहिए 10 बार बोलने से पहले कि क्या बोल रहे हो, जो बोल दिया वो वापस नहीं आएगा। तो
Right,
वो
right,
बहुत जरूरी है, बिकॉज अभी किसी की कोई अकाउंटेबिलिटी नहीं रहती है हमारे सोशल मीडिया प्लेटफॉर्म्स पे ना, जिसने जो बोल दिया वो कह के निकल गया। लेकिन अब जिस तरीके के लॉज आ रहे हैं और जैसे हमारा लॉ इवॉल्व कर रहा है, पीपल विल बी हेल्ड अकाउंटेबल। अब आपने जो बात बोल दी उससे आपको लिंक किया जाएगा, वो आपको आपको उसके आंसरेबल हो गया। और वो अगर गलत है, और ऐसे हो रहे हैं केसेस, इसी अब कोई किसी के लिए कुछ बोल देता है तो डिफेमेशन का केस आता है ना,
right,
सो यू आर बीइंग प्रोसिक्यूटेड। अगर कोई ऐसी कोई स्टेटमेंट दे देता है जो क्रिमिनली डिफेम करने के लिए किसी को, या कोई झूठे केस में फंसा देता है, तो उसके अगेंस्ट भी एक्शंस हो रहे हैं ना। तो बिकॉज अभी जो है, जितना टेक्नोलॉजी एडवांस होगा उतनी अकाउंटेबिलिटी आ जाएगी। तो ये बहुत ज्यादा इंपॉर्टेंट है कि सेंस होनी चाहिए, कब क्या बोलना है, कब नहीं बोलना है, और कितना बोलना है, कैसे बोलना है। हम डेमोक्रेसी में हैं, बहुत अच्छी बात है, डेमोक्रेसी में हर बात कहने का अधिकार है, लेकिन साथ में एक मॉरल रिस्पॉन्सिबिलिटी भी है कि जो बात कही जा रही है उसको सही तरीके से कहा जाए।
right, right, right,
अनचेक्ड डेमोक्रेसी इज ऑलवेज, इट्स ऑलवेज हार्म फॉर अ स्टेट।
right,
दैट्स व्हाट आई बिलीव।
right,
डेमोक्रेसी पे थोड़ा सा चेक होना चाहिए, और वो चेक गवर्नमेंट से नहीं आना चाहिए, वो चेक अपने आप से आना चाहिए कि ये, एज आवर कॉन्स्टिट्यूशन से, इस प्रियम्बल में है ना, वी द पीपल ऑफ इंडिया, हमने अपने आप को वो संविधान दिया। तो वो हमारी ही रिस्पॉन्सिबिलिटी है कि हम अपने आप पे भी एक वो चेक लगा लें कि क्या बोल रहे हैं, सोच के बोले।
correct,
वो सेंस आनी चाहिए, और उस सेंस के लिए कुछ काम करना चाहिए। आई 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 डोंट नो वो क्या स्टेप हो सकता है, बट आई थिंक जो एक्सपर्ट्स हैं इस फील्ड के, वो कुछ ऐसा प्लान करें या कुछ एक्टिविटी ऐसी करें कि वो एक हर, और जब ये होने लग जाएगा, ट्रस्ट मी, आई बिलीव हमारा हमारा कंट्री विल बी नो मैच।
right, right. No, I mean this is power. This is power now, and that says that thing in Spider-Man, with great power comes great
हाँ
responsibility.
हाँ,
So yeah, that should be the thing. Makes sense. Uh, we have talked about so many things, Shivendra. One thing that I'd won't want to uh that I don't want you to miss before you leave us with heavy heart, which is about there are. I mean, recently, I guess just a week back, we have seen there is a buzz going on that there are some laws that are changing, some new laws are coming. I now. मे बी आई एम सेइंग इट रॉन्ग, कोई लॉ नहीं बदल रहा है, कोई लॉ चेंज नहीं हो रहा है, कुछ अमेंड हो रहा है, कुछ हट रहा है, सब समथिंग इज हैपनिंग. But if you can put it in very simple words, like in just 5 points for me or few points for me, ki what really is happening? What really happened in last week? And what are those laws that changed or amended?
हाँ, सही। अभी तक, एज ऑफ नाउ टुडे ऑल्सो, क्रिमिनल लॉ को गवर्न, जो मेजर एक्ट्स हैं जो गवर्न कर रहे हैं, इट्स आईपीसी, इंडियन पिनल कोड, सीआरपीसी, द कोड ऑफ क्रिमिनल प्रोसीजर, एंड इंडियन एविडेंस एक्ट। ये तीन लॉज गवर्न कर रहे हैं। अब जो ऑफ कोर्स असेंट भी मिल गया है प्रेसिडेंट का, अब तीन नए लॉज हैं इसी को रिप्लेस करते हुए। ठीक है। जो पहला पॉइंट, जो गवर्नमेंट का, जो 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 पहला उनका उनका भी पहला पॉइंट है कि जो कॉलोनियल लॉ है, जो ब्रिटिशर्स का दिया लॉ है, वो हम एक इंडिपेंडेंट सोवरेन कंट्री के लिए नहीं है, तो ये इंडिया के लिए एक लॉ जो इंडिया को डिफाइन करता है, इसलिए हम नया, और आज की टेक्नोलॉजी के हिसाब से जो, बिकॉज जो ऑफेंसेस तब 1862 में 60 में हो रहे थे, वो अब उसी तरीके से होंगे ऐसा नहीं है ना, अ लॉट ऑफ टेक्नोलॉजी इज इन्वॉल्व, तो उससे डील करने के लिए एक नया लॉ आया। दैट्स वन थिंग। सेकंड, जो आप बोल रहे हो कि अमेंड हो रहा है, अमेंड कुछ नहीं हो रहा है।
Okay.
अमेंडमेंट होता है कि जो लॉ है, अमेंडमेंट तब कहते हैं इससे कि आईपीसी इज देयर, और आईपीसी के अंदर कोई एक रेलेवेंट सेक्शन को अमेंड कर दिया, या तो ओमिट कर दिया या कुछ ऐड कर दिया, जैसा कि 2013 में हुआ था आफ्टर निर्भयास केस। 376 के अंदर डेफिनेशंस जो हैं थोड़ी सी चेंज करके उसके अंदर और सेक्शन सब क्लॉजेस इनकॉर्पोरेट किए गए थे। दैट इज अमेंडमेंट। यहाँ पर लॉ एक रिप्लेस हो रहा है, इट्स अ न्यू लॉ, इट्स नॉट एन अमेंडमेंट।
Okay.
ठीक है। दूसरा, इस प्रोसीजर के अंदर सी बहुत सारी चीजें ऐसी हैं जो सेम है पुराने लॉ से, पुरानी आईपीसी से। प्रोसीजर की नहीं, मैं पहले आपको सब्सटैंटिव लॉ की बता दूं। लेट्स आईपीसी के अंदर है, और भारतीय दंड संहिता में, तो जो दोनों के कई सारे सेक्शंस हैं वो सेम है। सेम इन द सेंस, सेम प्रिंसिपल्स पे काम कर रहे हैं। डेफिनेशन थोड़ी बहुत चेंज है। ठीक है। ऑफ कोर्स डेफिनेशन चेंज होना लाजमी भी है, क्योंकि जिस तरीके से ऑफेंस, अब कितनी जनरेशन निकल गई। ठीक है, इट्स मोर देन 100 years, एक सेंचुरी से ज्यादा का समय हो गया है। तो वो जिस तरीके से पहले ऑफेंस हो रहा था उस तरीके से आज ऑफेंस होगा जरूरी नहीं है, और लाजमी भी नहीं है, होगा भी नहीं। तो वो उसको चेंज करने के लिए क्या क्या जरूरी है, जो चेंज आया जिस वजह से बेनिफिट थे, जो लेक्यूनास थे जिसका फायदा उठाया जा रहा था, और जो एक्चुअली ऑफेंडर्स है निकल रहे थे, तो उसको प्लग इन करने के लिए वो वहां पर यूज हुआ। अब आते हैं प्रोसीजरल लॉ पे। इसी तरीके से प्रोसीजरल लॉ में, बिकॉज सब्सटैंटिव लॉ चेंज हुआ हमारा, तो उसके प्रोसीजर्स भी थोड़े बहुत चेंज होंगे। ठीक है। ऐसा नहीं हो सकता कि नया लॉ ले आए, नया सब्सटैंटिव लॉ ले आए, लेकिन उसके प्रोसीजर्स जो है हम वही वाले चला लें, तो फिर कॉन्फ्लिक्ट होगा। तो इसी वजह से नया प्रोसीजरल लॉ है। फॉर एग्जाम्पल, जैसे पुलिस कस्टडी रिमांड पहले हमारे 15 दिन का था, अब उसे बढ़ा दिया गया है। ठीक है। सही है गलत है हम उस पर नहीं जा रहे हैं अभी, कि कॉन्स्टिट्यूशनल वैलिडिटी इसकी क्या है, या ह्यूमन राइट्स के ओपिनियन से, या ह्यूमन राइट्स के कंसिडरेशन से इसका क्या, इसका क्या कहना है, इस पे क्या कहना है, उस पे मैं नहीं जा रहा हूँ अभी। अभी मैं आपको जो एक्चुअली में चेंज हुआ वो बता रहा हूँ। सिमिलरली, पहले लॉ के अंदर हमारे जो डिस्क्लोजर स्टेटमेंट है, डिस्क्लोजर स्टेटमेंट आप ऐसे समझें कि आपने किसी को अरेस्ट किया, किसी एक्यूज्ड को, तो उसका आपने कोई स्टेटमेंट लिख लिया। ठीक है, कन्फेशनल स्टेटमेंट।
Hmm.
तो वो पहले कोर्ट में एडमिसिबल नहीं होता था, क्योंकि पुलिस किसी को भी डरा धमका के अपने प्रेशर में किसी से भी कुछ भी लिख सकती है। ठीक
Right.
है, उस पर साइन करा सकती है। अब वो एडमिसिबल हो गया है नए एक्ट में। ठीक है, अगर वो वीडियो रिकॉर्ड किया जा रहा है कन्फेशनल स्टेटमेंट, तो वो एडमिसिबल हो गया है। सही है गलत, दैट इज डिफरेंट, बट ये चेंज है। अब वो चेंज क्यों है, दैट हैज टू बी रेड इन corroboration ऑफ आईपीसी। ठीक है, तो ये सारा बातें। अब जैसे बेल है, ठीक है, 41A है जैसे हम अभी डिस्कस कर रहे थे। तो 41A की एक रिक्विजिट होती है, एक प्री रिक्वायरमेंट होती है कि आप 41A का नोटिस अगर आप इशू कर रहे हो तो उसमें लिखोगे कि क्या रीजंस हैं आपको आपके।
अरेस्ट करने
हाँ, आप एक्सप्लेन करोगे 41A को, और 41A देने के बाद जब आप अरेस्ट करोगे तब भी आप रीजंस लिखोगे कि मैंने 41A का नोटिस इशू कर दिया, लेकिन अभी भी मेरे को ये रीजंस हैं जिस वजह से मैं इस पर्टिकुलर बंदे को अरेस्ट कर रहा हूँ। ठीक है, ये था पुराना। अब नए लॉ में 41A का नोटिस देना आई थिंक मैंडेटरी तो है, लेकिन उसके रीजंस रिकॉर्ड करना नहीं है। तो दो ना दो एक ही बराबर हो गया। ठीक है, तो ये चेंजेस हैं, ऐसे कई सारे चेंजेस हैं।
बट एज यू सेड, सही है गलत है
I think that will
वो
be
छोड़ देते।
the topic for another discussion. It's uh, it's a very deep rooted, and of course you'll see a lot
Sure.
of opposition and lot of support in the new act. But I would like to reserve my
Your
opinion unless
thoughts.
I go through the entire act. क्योंकि of
Right.
course I'll be honest, मैंने अभी पूरा बिल नहीं पढ़ा है। अभी पूरा एक बार जब पढ़ लेंगे तभी हम एक ओपिनियन फॉर्म करें तो अच्छा है। क्योंकि बहुत सारी चीजें जो ऊपर से देखने में लगती हैं एक्चुअली में वो नहीं होती हैं। बहुत
Right.
सारे चेंजेस हैं, कंप्लीटली चेंज हो गया है। आई वाज रीडिंग वन आर्टिकल जिसके अंदर ये लिखा हुआ था कि सॉरी, आई एम मिसिंग आउट ऑन द पर्सन्स नेम जिसने ये आर्टिकल पब्लिश किया था। वी वाज डिस्कसिंग दिस लॉ, बट उसने एक बहुत अच्छी बात लिखी हुई थी कि लॉर्ड मक्लॉय ने जो द वन हु ऑथर्ड आईपीसी, उन्होंने जो लॉ लिखा वो अभी तक काम आ रहा है। तो क्या ये लॉ इतना इतना पावरफुल या इतना वर्थ है कि ये आने वाले 100 साल तक चल सकता है? बिकॉज दैट वाज इन 1860, implemented in 1862, still in force, still applicable, still working out good। तो क्या इसकी वो वर्थ है? तो दैट नीड्स टू बी डिबेटेड। तो वो डिबेट होना चाहिए। हाँ, ये जरूर है कि मैं ये जरूर बोलूंगा कि बहुत रश में ये लॉ पास हुआ। there should have been a debate, but then again this government is known for doing known for achieving unbelievable feats। तो इट्स गुड, और कुछ एस्पेक्ट्स इस लॉ के अच्छे भी हैं। सी हमारे जो बहुत बहुत ग्रे एरिया रहता था जहाँ पे ऑफेंसेस वो वाले आ जाते जहाँ पे टेक्नोलॉजी थी। पहली
Hmm.
बार टेररिज्म डिफाइन हुआ है हमारे उसमें, दैट इज गुड। अभी तक हमारी आईपीसी में टेररिज्म डिफाइन नहीं था। सो नेशनल
Okay.
सिक्योरिटी की बात करें तो टेररिज्म डिफाइन हुआ।
Okay.
ठीक है, तो प्रो और कॉन्स दोनों हैं, मैं ये समझता हूँ। बट अभी डिबेट होना चाहिए इस पे। और
So can this all be challenged in the courts?
yeah, of course it
Yes.
can be, of course, and you'll get to see that it is being challenged, because of course every ह्यूमन राइट्स के बेसिस पे जाएंगे तो वो चैलेंज करेंगे कि पीसी रिमांड को 15 दिन से बढ़ा के आई थिंक 60 या 90 डेज तक का किया है। सो ऑफ कोर्स एक एक विंग है, एक साइड ये बोलेगी कि एक्स्ट्राऑर्डिनरी पावर्स दे दी हैं इन्वेस्टिगेटिंग एजेंसीज को। गवर्नमेंट हमारी बोलेगी कि नहीं, ये रिक्वायर्ड है। सो ऑफ कोर्स इट विल बी डिबेटेबल, एंड ऑफ कोर्स इट foremost it has to be in light of what the Supreme Court in its judgments is being saying from time and again कि भैया ये आपको फॉलो करना है, ये ह्यूमन राइट्स। अगर उसको ऑफ कोर्स ओवररूल करने के लिए कुछ आ जाए तो ऑफ कोर्स वो एक नया डिबेट हो जाएगा। सो सुप्रीम
You
कोर्ट
use the word in virus, out virus.
अल्ट्रा
You
वायरस एंड इंट्रा वायरस।
sorry, ultra virus and intra virus. So if it's ultra virus, it should not
Yeah, of course,
go
ultra
ahead
that has to be seen with the constitution। See,
with the constitution.
सुप्रीम कोर्ट एवरी लॉ, जो भी लॉ चैलेंज होता है उसकी कॉन्स्टिट्यूशनल वैलिडिटी पे, तो उसके अंदर हाई कोर्ट या सुप्रीम कोर्ट जहां पर भी चैलेंज कर रहे हैं वो यही एक ऑब्जर्व ये सिर्फ इशू सिर्फ इतना सा है कि हमारे कॉन्स्टिट्यूशन ने हमारे को कुछ चीजें दी हैं। ठीक है, वो जो लॉ हम लाए वो क्या वो कॉन्स्टिट्यूशन के उस पर्पस को, जो भी कॉन्स्टिट्यूशन का जो पार्ट है जो उस लॉ से रिलेट कर रहा है, जो कंसर्न है, क्या कॉन्स्टिट्यूशन को डिफीट कर रहा है? और अगर कॉन्स्टिट्यूशन को डिफीट कर रहा है तो वो लॉ नहीं चलेगा। वो फिर दैट लॉ हैज टू बी स्ट्रक डाउन, क्योंकि वो कॉन्स्टिट्यूशन को से कॉन्फ्लिक्ट में है। कोई भी लॉ, इस सिंपल लैंग्वेज में, अगर सिंपल टर्म्स में मैं इसको रखूं तो ये है कि कोई भी ऐसा कानून जो हमारे संविधान से कॉन्फ्लिक्ट में है, जो उससे अलग जा रहा है, उसको कॉन्फ्लिक्ट कर रहा है, उसको कानून को वापस लेना पड़ेगा। वो कानून नहीं है, वो दैट लॉ will be taken back, it will be repealed, as simple as that.
Now that we'll see in the coming future.
हाँ, दैट ऑफ कोर्स अभी तो आई थिंक 3 से 4 महीने तो इंफ्रास्ट्रक्चर के लिए ही लगेंगे, नए लॉस के लिए। अभी तो नोटिफाई भी नहीं हुआ है, असेंट मिल गया है। नोटिफिकेशन में भी 15-20 दिन, 25 दिन तो ऑफकोर्स जाएंगे अभी,
So, but it will
26
be
जाएंगे।
still called IPC or
नहीं
CRPC
नहीं,
or
नाम बदल गए हैं।
ISC. वो नाम ही
भारतीय,
चेंज है.
ऑफ कोर्स इससे मुझे याद आया, मद्रास की हाई कोर्ट की बार एसोसिएशन आई बिलीव इस चैलेंजिंग की ये नाम हमको सूट नहीं करता है, हम ये हम पे थोपा जा रहा है नाम, बिकॉज भारतीय यूज हो रहा है
भारतीय.
इंस्टेड ऑफ इंडिया। तो उनका अपना एक कंसर्न है, वो अपना एक चैलेंज करेंगे। सो ऐसे इश्यूज उठ के आएंगे, ठीक है, बट ये कॉन्स्टिट्यूशनल नहीं है, बहुत ऊपर ऊपर के इश्यूज हैं। अब
राइट,
वो
राइट.
एक आ जाएगा कि भारत नहीं है, इंडिया है, एंड एवरीथिंग दैट इज वो,
Yeah,
उसको
India that is
उसको
Bharat,
कौन,
Bharat that is India.
हाँ, उसको वो कलर देने की कोशिश करेंगे, रंग देने की कोशिश करेंगे, दैट इज डिफरेंट। बट मैं एक एग्जांपल दे रहा हूँ आपको, मैं कहीं पढ़ रहा था, आई थिंक लाइव लॉ वगैरह पे या कहीं पढ़ रहा था मैं, कहीं तो पढ़ रहा था मैंने, कहाँ पढ़ा है आई एम नॉट एबल टू रिकलेक्ट, लेकिन वो कि वो दे आर इन प्रोसेस ऑफ चैलेंजिंग की ये हमारे पे ये नहीं है पहले वाला, ये तो वो सब है। ऑफ कोर्स लॉ तो नया आएगा, वो आ ही चुका है, बट उसमें कुछ सेक्शंस ऐसे हैं ऑफ कोर्स जो चैलेंज होंगे, पूरा नहीं चैलेंज होगा। कुछ ऐसी चीजें हैं जो लगेगा कि नहीं ये ह्यूमन राइट्स के अगेंस्ट हैं, वो चैलेंज होंगी, या कुछ जो सुप्रीम कोर्ट के जजमेंट्स थे उनकी कॉन्फ्लिक्ट में हैं तो चैलेंज होंगी। ऐसे चैलेंज होगा, हो सकता है पूरा भी लॉ कोई गवर्नमेंट कोई ऑपोजिशन चैलेंज कर दे, ठीक है, लेकिन क्या बेसिस हैं वो अभी आगे ही पता चलेंगे, और वो ज्यादा क्लियर पिक्चर तब मिलेगी जब वो एक बार मैं भी पढ़ लूँ, तो मैं बेटर
So,
रहूंगा पोजिशन में बताने
no,
की।
no, yes, that's right, that's right. So, दो तीन points तो आपने बताए, which of course has enlightened us and will also enlighten our viewers. It was an impactful session, Shivender, for me.
थैंक यू,
There are
थैंक
a lot of things that I'm taking from this. Uh, I always say that there is something called pseudo smartness. You see, smartness maybe that is not used on daily basis, but that you gradually become smart on something that you don't know about.
यू,
This is one that few
थैंक
hours that we have spent together. So thank you very much, Shivinder, for
प्लेजर।
this lovely session. I had a lot of things, and I guess I covered a lot of things, and I forgot uh, some of it. But definitely, we'll be planning a new session with you. But do you have anything to say? I don't have.
It was a pleasure, of course. It's always a pleasure joining with you guys, and of course, the job you are doing. I mean, this this needs to be appreciated because इन अ वे जो अभी मैं आपको बता रहा था, आई थिंक हमारा बहुत पहले एक ये डिस्कशन हो रहा था जिसके अंदर आपने यू मेंशन कि लोगों को कैसे पता चले। सो यू आर बीइंग दैट प्लेटफॉर्म विच इज ब्रिंगिंग नॉलेज टू द कॉमन पीपल, टू द लेमैन, कि लॉ क्या है। एंड ऑफ कोर्स जो लॉ बेयर एक्ट में आ रहा है, बेयर एक्ट इन सेंस जो बुक्स में आ रहा है, जो एक्ट्स में आ रहा है, वो पढ़ के नहीं समझ में आ रहा है, या न्यूज में जो आज बताया जा रहा है, दैट इज नॉट लॉ। इट्स इट इज द प्लेटफॉर्म लाइक योर्स जहां पर एक्चुअली आप एक्सपर्ट से, या जो वहां पे प्रैक्टिस कर रहे हैं उस चीज को, जो जानते हैं, जिनको फर्स्ट हैंड नॉलेज है, उनके साथ इंटरेक्ट करके उसको सिंप्लीफाई करके। ऑफ कोर्स बहुत बेसिक एग्जांपल दूंगा, अगर टीचर्स की जरूरत नहीं होती तो सिर्फ बुक से सब टॉप करते ना,
Right.
उसको सिंप्लीफाई करने के लिए ही तो एक्सपर्ट्स की जरूरत होती है, और वो आप लोग बहुत अच्छे से कर रहे हो। आई हैव सीन योर वीडियोस, तो आप जो एरियाज को टच कर रहे हो, दैट इज वेरी, आई रियली अप्रिशिएट, दैट इज कमेंडेबल.
Well,
I,
thank you,
I
Shivendra. That means a
really
lot.
love joining with you guys.
Hey, that means a lot, Shivendra. And if you want to learn and meet with Shivendra in person, he's joining us in the conference. I'm sure about it. So I'm going to request him to join actually. But
Certainly, certainly.
this has been a great session. Thank you very much for being part of the premiere episode of Lex Talk
Oh,
podcast.
it's a
This
pleasure.
is the very first podcast, but we're going to go very long from now.
I certainly wish you all the best, and it's my pleasure. I didn't knew that it was a premiere episode, but I'm really thankful. Thank you.
Hey, thank you, Shivendra. Thank you very much. And for our viewers, if you like this podcast, and if you are still here for like 2 hours, make sure that you like this video. Leave a comment. Tell us what you like, what you didn't like. We are always there to kind of have good and bad, all kind of comments and try to polish ourselves. And click on that red button to subscribe to Lex Talks YouTube channel. And I'll see you around in the next episode very soon. Thank you very much. Thank you, Shivendra.
Thank you. It's a pleasure.